Last time on Corrupt Sheriff and Friends.
I told Mr. Noel, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be there right there with him. Now, what is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today.
Damn! Greetings, my friends, and welcome. We are back today in the great state of Indiana, Clark County to be exact, where corrupt Sheriff Jamey Noel has made a mess of things. It's what we like to call around here a dumpster fire. If you missed yesterday's episode, I suggest you go back and watch it, at least the first third of it. Get a little background on the case, because it's pretty messy. There's 133 cars involved. You need to know about that. Today we carry on and learn how widespread the corruption is, how much of the family was involved, and things get kind of nasty. Also, make sure you hit that subscribe button and hit the bell, the solid one, so you don't miss tomorrow's episode, because the hearing with the mistress gets really nasty. Let's go to court.
Thank you,
Good afternoon, Your Honor.
Thank you very much. Ten C01 2403 MC 634, that being in criminal contempt of Jamey Noel, and 10 C01 2311 F5 297, that being State of Indiana versus Jamey Noel. You may have a seat. Thank you. Mr. Boyles, it's my understanding you have the gentleman here that conducted the search of the Noel properties.
I do, Your Honor. Let the record reflect that on April 17th, after our original contempt hearing, I requested this court to consider appointing an independent person to do a complete, thorough search of all four of the houses that Mr. Noel had control over. The court accommodated us and issued that order providing that. We had contacted Mr. Todd Brown, a retired Federal Bureau of Investigation officer, who we asked to conduct the search. Mr. Brown conducted the search, and pursuant to the court order, we filed on May 1st a copy of the report along with an exhibit that identifies all of the items that Mr. Brown located in the house, and we would like to call him as a witness, Your Honor, to have him detail for the court the location and the items that were taken.
You may.
Thank you.
Mr. Brown? Please have a seat. You're very, very high. Do you solemnly swear or affirm under the penalties of perjury testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Your Honor.
Thank you. Have a seat. Your witness, Mr. Boyle.
Thank you, Your Honor. State your name for the record, please.
Todd Brown.
And Mr. Brown, are you retired from the Federal Bureau of Investigation?
Yes, I am.
How long have you been retired?
Since October of 2022.
Okay. And when you were an agent with the Federal Bureau of Investigation, where were you stationed?
I was stationed first in Louisville, Kentucky, And then after 10 years, I was transferred to the New Albany Resident Agency in New Albany, Indiana.
Okay. Do you have any specialized training in your job as an FBI agent?
I do. I received basic training at the FBI Academy in Quantico, Virginia, basic new agents training, and then received additional training once I was out in the field. And I was also a member of the evidence response team while I was assigned to the Louisville Division.
Okay. Mr. Brown, when I contacted you, I asked you if it would be within your capacity to do an inventory of all our client Jamey Noel's properties that he owned for the purpose of securing any additional weapons that might be there, even though the court didn't authorize that, also to indicate whether any ammunition located in those locations. Is that correct?
That's correct.
Also, I've asked you that you were aware at the time that you were going to do the search that Mr. Noel was given permission by this court to have a shotgun at the residence. Is that correct?
That's correct.
Okay. Well, let's start with what properties were you assigned to search?
I was assigned residence at Old Tay Bridge and a pole barn with a cabin next to it at, I believe, 709 Old Salem Road in Jeffersonville. The residence was also in Jeffersonville.
Okay.
Then a green barn at 711 Old Salem Road, and then a house on Turnberry. I believe it was 2408 Turnberry.
Also, they were also located in Jeffersonville?
Yes, all the properties were in Jeffersonville.
In order to properly conduct such a search, what did you do? How did you prepare yourself?
After receiving the specific locations, once I got to the first location, I took what I would consider entry photos, which is just general photos outside of the property. And then once I entered the residence, I took photos as I moved through the residence.
Okay. And did you conduct it in what I would call an orderly manner, starting on one floor and went to another floor? Is that kind of how you did it?
Yes, yeah.
Was anybody there to assist you?
Paul Meyer was present, but I completed the search myself.
Okay. Who is Paul Meyer?
He's a individual that is working on this case, I believe.
Is he also retired from the Federal Bureau of Investigation?
He is. He and I were assigned together in New Albany.
Okay. And he's the one that contacted you on my behalf to see if you would independently do the search. Is that correct?
Correct.
All right. Well, let's start with the first property that you talked about, which would be 3001 Old Tay Bridge in Jeffersonville. Is that the residence?
Yes, sir.
Okay. Were you able to locate any weapons in that home?
I did.
And what did you locate?
I located a Glock 26 pistol, semi-automatic pistol, a Sig Sauer 1911 semi-automatic pistol, and a shotgun.
Okay, let's be very specific on the first, the Glock 26. Did you also take a photograph of where that was located?
I did.
Okay, could we have a picture up on the screen which would be for the purpose of having you identify the area where that weapon was found, is that correct?
Yes, sir.
And what room of the house is that?
That is a closet next to the laundry room. As you're looking at the photo, the laundry room is in the background of the photo, and the closet is the main part of the photo.
And that's on the main floor of the house?
Yes, sir.
Okay. And I noticed that there's a lot of material in that closet. Was that there when you went through it that day?
Yes, sir.
Where was the gun located?
It was located...
Why don't you come off the stand if the court would permit and point to the photograph?
It was located in with all these items that are shoved into the closet area here.
Was it on the floor? Was it in an item, or where was it?
Actually, at the time that I located it, I was pulling items out of the closet, and there was a nylon zip case, and I opened the nylon zip case to see what was in it, and that's when it was a gun box inside the zip case. I opened the gun box, and the gun and one magazine was in the box.
Was the weapon loaded or unloaded?
It was unloaded.
Can we show the second photograph, please? We're now showing a new photograph of a picture weapon. Can you describe that, please?
Yes, that's the Glock 26 pistol that I found, and that's the manner in which I found it. It was in the box, locked back, and the magazine was in the box also.
And that's the one that came from the closet,
Yes, sir.
correct?
Yes, sir.
Okay. You can stand there because we're going to move to the next location. Did you also, as part of your search, in searching all of the house, went to the master bedroom?
I did.
Okay, and is that the photograph of a closet located in the master bedroom?
Yes, sir.
Okay, and was there a weapon located there?
There was.
And what was the weapon?
It was a 6-hour 1911 semi-automatic pistol.
Okay, and where was that weapon located?
It was located in this area of the floor. There was a pile of stuff on the floor.
Was that pile on top of it?
I'm
I
sorry.
couldn't see.
Oh, I'm sorry, sir.
If you'll do that again from the other side.
No, I'm sorry. I located it in this area of the closet. There's a pile of clothes and all sorts of stuff there on the floor, and I found it as I was pulling stuff out.
Thank you.
Was that located in a bag itself, or was it just loose?
The firearm was located in what I would call a utility belt in a holster.
Okay. I think she's reaching for a pointer. And again, that's in the master bedroom.
Yes, the master bedroom, then when you were facing the master bathroom, there are closets on either side of a hallway leading from the master bedroom to the master bathroom, and this was the right side closet.
Okay. You can return to the witness stand, please. And is that the photograph of the weapon that you found in the master bedroom closet?
Yes, sir.
Okay. Was that loaded or unloaded?
The weapon was loaded with a magazine in the magazine well, but there was no round in the chamber.
You secured both these weapons, is that correct?
I did.
And you have them under lock and key now, is that correct?
Yes, sir.
Okay.
Assume that was a 45.
Yes, sir.
Judge, if we could have this marked and we'll offer that into evidence. And it's a photographs of all the pictures you took in all the properties.
Any objection from Mr. Hurley?
No, Your Honor.
How you marking it, Tom?
One, State's Exhibit 1.
I'm sorry,
State's Exhibit 1.
not state to do.
I mean, Defendant's Exhibit 1.
So defendant's exhibit 1 and then
Right,
everything.
sorry.
We're always blue state. Mr. Brown, I'm going to hand you what's been marked for identification as Defendant's Exhibit 1. And then, can you identify that?
Yes, sir.
What is that?
That's a thumb drive that contains the photographs that I took from examining all 4 properties and also photographs of all items that I located.
This time, Your Honor, we would offer Defendant's Exhibit 1.
No objection, Your Honor.
So defendant's exhibit 1 admitted without objection.
Your Honor.
Thank you, sir.
Thank you, sir. As part of your responsibility, Mr. Brown, did you also inventory what I requested, any kind of ammunition that may have been in the house while you were there?
Yes, sir.
And the report that you filed as Defendant's Exhibit A lists all the ammunition from both the master bedroom, the garages, the theater room, master bedroom, basement, unattached garage, and then you also went to 709 Old Salem Road for the purpose of examining it,
Yes, sir.
and you found no weapons in that location, correct?
No, sir.
But you did find ammunition which you categorized.
Yes, sir.
You found it in the loft living room and loft first bedroom, and the loft storage tote, and the garage entry, is that correct?
Yes, sir.
You then went to 709 Old Salem Road, and that location, nothing was found in that location?
Correct. That was the cabin.
And then you went to 2408 Turnberry Drive, Jeffersonville, is that correct?
Yes, sir.
And nothing was found there?
Correct.
And all the ammunition that you did, you have it under lock and key under your custody, is that correct?
Yes, sir.
Mr. Brown, I also advised you that this court, after the initial hearing, had permitted Mr. Noel to keep a shotgun. Is that correct?
Yes, sir.
Were you able to locate such a weapon at the house?
Yes, sir.
Okay. Describe what it was.
Was a Remington 1187 police model auto-loading shotgun.
And was that weapon loaded when you discovered it?
No, sir, I don't believe it was.
Is that weapon still at the house?
No, sir, to the best of my knowledge, it is not.
Did someone in the house indicated they wanted it removed?
Yes, sir.
Okay. And was it removed?
To the best of my knowledge, yes.
Okay. And it's currently located in Mr. Wilder's office under his protective custody. Is that correct?
Yes, correct.
So those are the entire amount of weapons that you found when you searched all 4 properties. Is that correct?
Yes, sir.
Could we show the picture? I think Mr. Wilder has it up. Is that the shotgun that was at the home?
Yes, sir.
And is that the Remington weapon?
Yes, sir.
Okay. And that's no longer at the house. Is that correct?
That's correct.
So based upon your testimony and your experience and an independent examiner of all properties that Mr. Noel owns, there are no weapons in any of those properties. Is that correct?
To the best of my knowledge, that is correct.
I have nothing further.
Cross-examination, Mr. Hurdle.
If he was allowed to have the shotgun, why did you remove it?
At the request of his wife,
Was she present when you were there?
she was not.
You spoke to her, though?
No, sir. Paul Meyer spoke to her, and Paul Meyer advised me that she wanted the weapon removed.
And you said Paul Meyer's working on the case. He works for the defense,
Yes, sir.
and he's also retired FBI?
Yes, sir.
And the two of you work together?
With the FBI, yes.
I'm sorry, you said you retired from the FBI in October of 22. When did you start?
Started April 15, 1991.
Approximately how many rounds of ammunition did you find?
It would be a really rough estimate. I've detailed it in my report. Approximately 5,000 rounds,
What caliber?
various calibers. They're 9mm, 45, 380, 5.56. 7.62. That's 22. And there could be others. That's what I recall.
The two guns that you found, the Glock and the SIG,
Yes, sir.
were you told where to look for those?
No, sir.
Nobody told you to look in the master bedroom closet or the laundry room closet?
No, sir.
Did you have any contact with the defendant, his wife, or his daughter?
With his daughter.
Which daughter?
The Grace,
What was the extent of that contact?
just to advise that I was at the home.
Had you ever met any of them before?
No, sir.
Had you ever met the defendant before?
I do not specifically recall ever meeting the defendant.
Even though he was in law enforcement for about 30 years, that overlapped the same time that you were in law enforcement?
That's correct. I don't specifically recall meeting him.
Did you search any vehicles?
I did.
Ammunition or weapons found in any cars, trucks, or other types of vehicles?
No, sir.
Do you recall off the top of your head what vehicles you searched?
There was a Trans Am and a BMW at the residence. Then there were several, what I would call classic cars, older cars, at the pole barn at 709 Old Salem Road.
Several, more than 10, less than 10?
I would say 10 to 12.
Thank you, Mr. Brown. Nothing else.
Mr. Wells, anything else?
I have no further questions. Thank you.
Mr. Brown, you retired in 2022.
Yes, sir.
Were you able to keep your service revolver or sidearm?
No, sir.
Do you have one you typically carry?
I do.
You know where it's at all times?
Yes, sir.
Did you always know where your service sidearm was? It's probably not a revolver, was it?
No, sir. Yes, sir, I did.
So to find a service revolver, I keep saying revolver, service firearm, in a duty belt with other mags, that's not too far-fetched to believe that one would know where that was at, would it? Rhetorical question, you don't have to answer.
Yes, sir.
Just reinforces my decision to impose sanctions. If that prompts any further questions.
None for the
Not-
defense.
I do have another question or two. The Remington shotgun, was it in a box when you found it?
No, sir.
Was it near a box? A Remington firearm box?
Not that I recall.
Did it still have tags on it?
No, sir.
Where was it at?
I located it in the basement, what I generally term the theater room.
And not loaded?
No, sir.
Not much use for self-defense, is it?
No, sir.
You were in the upper area and you needed a firearm for self-defense, where would you go? Of the ones you found?
The closest one would be the 6 hour 1911.
Okay. No other questions? That prompts any questions?
One question, Your Honor. Mr. Brown, was there any 12-gauge ammunition found?
Yes, sir.
That's all, Judge.
Mr. Boyles, I'm not going to impose any further sanctions today because it was not certified to me that there was no further firearms. But after today, if there's any further firearms found, there will be additional sanctions. So if your client needs to tell you something, he needs to tell you right now. You need to take a few moments and ask.
I'd be happy to, Your Honor.
Why don't we go off the record so he can speak with his client?
The one thing we would add,
Hold
Your
on.
Honor, is the duty weapon.
Let us get back on. Okay, we're back on that. Go ahead.
The only thing we could add, Your Honor, is there's no weapons in the house now, and the duty weapon was seized on the original search. It was in the console of his car.
Okay,
So the one that was found was not the duty weapon.
okay.
Thank you. I have no questions.
Why was it in a service holster with additional mags? And you don't have to answer that.
Well, because I don't carry guns, so I don't know, Judge. I got a BB gun.
That's all right. Mr. Brown, thank you. And thank you for conducting the search for me. I appreciate it. You're excused.
Thank you.
Anything else we need to address?
No further evidence, Your Honor.
Mr.
Nothing-
Hurdle,
No, Your Honor.
is there anything else we need to address while on the record?
I don't believe so. I think a chambers meeting on discussing trial dates and other things is appropriate, the court suggested.
Mr. Hurdle?
Your Honor, I know the court made its decision not to issue any more sanctions, but from the state's perspective, the finding of 2 additional weapons, one a service weapon, one that was loaded, easily accessible, is still concerning and troubling to the state. I know it is to the court as well. I don't know that the state has anything to offer other than that. The court issued a sanction last time and would reiterate its position before that the court orders are something to be followed, and hopefully that doesn't happen again.
Well, Mr. Hurdle, if it had been certified to me that there was no further weapons, and then these additional weapons were discovered, I promise you there would have been additional sanctions. But because that certification had not been made, I don't think it would be fair to do so. But I did give Mr. Boyles and his client warning, should any further weapons be found, there will be more sanctions.
Thank you, Judge.
Well, Judge, it was our position, as I told the court at our bench conference, that we wanted to do an independent to make sure that there would never be any ramifications on such. This court issued its order, and we're abiding by it. We would respectfully ask the court to possibly reconsider the amount of the time on the, because we're going to need, obviously, our client as we proceed to go through the discovery, and it makes it a little easier if he's available, but I'll leave that decision to the court.
Mr. Boyles, I know you have a job to do on behalf of your client, but as I indicated, finding these additional weapons just reinforces my decision. And a matter of fact, I wish I'd have made it longer. So, but I'll stick with the 60. Thank you.
Thank you, Your Honor.
We'll be off record.
On May 10th, 2024, 2 civil actions were filed against Jamey Noel by Indiana State Attorney General Todd Rokita. These were both filed in an attempt to recover some of the funds that were siphoned from publicly available monies that were associated with the Sheriff's Department and also the nonprofit organization.
It's now all in the family. The former Clark County, Indiana sheriff, 3 of his daughters, and his wife all in court today as part of a lawsuit. The Indiana Attorney General is trying to get back millions of dollars in taxpayer money the state says Noel's family and his associates spent on personal items. Here's Focus reporter Travis Breeze tonight and photojournalist Elijah McKenzie with more on the state's efforts to freeze their assets.
This was the first time that we saw Gracie or Josie Noel in an official courtroom proceeding. 5 Noel family members had to verbally agree to having the temporary restraining order extended for 30 days. That will prevent them from selling any of their assets.
Afternoon, everyone. Welcome to Washington County. Have a seat. Thank you. All right. Cause numbers 88, pardon me, habit, 10 C01 2405 PL 37 and 38. 37 being State of Indiana, ex rel. Todd Rokita, Attorney General versus Jamey Noel, Auto Owners, and Kenneth Eubanks. 38 being State of Indiana, ex rel. Todd Rokita, Attorney General of Indiana versus Jamey Noel, Gracie Noel, Josie Noel, Kevin Wilkerson, and Misty Noel. Prior to coming on the record, counsel for the parties had the opportunity to have discussions in regards to at least a possible temporary agreement. Mr. Stewart, it's my understanding that you're going to outline for everyone what you believe to be the agreement between you and the state of Indiana and all other parties.
That's correct, Judge.
Would you be so kind?
Yes.
Oh, by the way, this is Lauren. She's my intern for the summer. You guys be nice to her, okay?
And Judge, this would apply universally for all the parties, but I think there'll be some testimony elicited relative to each of the individuals.
That's my understanding of how this is going to work.
So as to the specific agreement, the parties would waive any issues related to the 10-day requirement contained in Rule 65B2. The TRO would stay in effect until and unless the agreed order is filed with the court or a hearing is held, whichever is earlier. Such hearing would be deemed an emergency matter. We would stipulate to that, and the court would retain jurisdiction over any and all emergency matters, including the preliminary injunction request filed by the state. In addition, all of the parties would turn over signed and verified under oath PAQs, which I'm still unsure what the terminology is, but those would be due this Wednesday at 12 o'clock. And all of this would be reduced to written format filed with the court. But that's my understanding.
And because we have so many lawyers here representing different parties, just for the record, can we clarify who is all here and who represents whom?
Judge, my name is Larry Wilder. I'm a lawyer from Jeffersonville, and I represent Mr. Noel.
How did I know you'd be the first to speak?
I'm the oldest here, Judge. Mr. Wells is absent.
All right.
Zach Stewart also on behalf of Jamey Noel, Your Honor.
Sunny Rashad, Judge, on behalf of Casey Noel, as well as Gracie and Josie Noel.
Your Honor, Bart McElhone on behalf of Misty Noel, Gracie Noel, and Joseph.
Mariel Riedel, along with Dane Kirk and Lydia Golden from the state on behalf of plaintiff.
Thank you. All right. Whoever's going to testify, please stand and raise your right hand. Do you solemnly swear or affirm under the penalties for perjury testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Okay, thank you. You may have a seat. Mr. Stewart?
You'd like us to
Or Mr. Wilder?
No, thank you, Judge.
On both cause
On both
numbers.
case numbers, yes. So, Mr. Noel, you understand that you're under oath? Yes. And you understand that we're here regarding 2 case numbers that you've been named in, right?
Mr. Wilder, let me interrupt
Yes,
just a
sir.
second. What's his name?
Charlie Myers.
Mr. Myers, are you with us now? Mr. Myers?
Technical difficulty.
Not here.
Tells me, I'll let you know.
All right.
Thank you,
Proceed.
Judge. No problem. So as we were saying, so Mr. Noel, you understand that you're here as a result of being named in 2 cases, correct?
Yes, sir.
And you heard the judge call those cases, right?
Yes, sir.
And you heard Mr. Stewart outline the agreement that has been reached among the parties contingent upon the court's acceptance, correct?
Yes, sir.
And you understood your rights as a defendant in this civil case. We explained those to you, correct?
Yes, sir.
You heard Mr. Stewart discuss timelines that we were willing to waive, right?
Yes, sir.
And also that we were willing to enter into an agreement where any and all emergency matters would be retained in the jurisdiction of Judge Medlock, correct?
Yes, sir.
And nobody made any threats, promises, or coerced you into agreeing with this in this case and these 2 cases, did they?
You're correct, Your Honor.
And it's under your own free will that you asked the court to consider accepting the agreement in both of the cases we're named in, right?
Yes, sir.
Judge, I have no further questions. Thank you.
Thank you, Mr. Wilder.
Did you need anything?
Just one
Yes,
clarifying follow-up. Sir, do you also understand that until and unless a stipulated injunction or a hearing is held, that the temporary restraining order that is currently in place would maintain as an order?
Yes.
Thank you.
Okay. Thanks.
Thank you so much.
All right.
Judge's back.
Are you with us, sir?
Hello, this is Charlie Myers.
Okay, Mr. Myers, we are on record now, so you'll be able to hear what's going on.
Fantastic. Thank you so much.
You're welcome. Bart, are you or Sonny gonna?
Yeah, I'll go ahead first with Ms. Noel. Misty, you heard the agreement that Mr. Stewart recited,
Yes, sir.
and you understand we're here today because you are a respondent in a civil action filed by the state of Indiana, and also there's a temporary emergency restraining order that has been sought.
Yes, sir.
And you understand the terms of that and the agreement that we have would mean that you must abide by that as an order of this court.
Yes, sir.
And we're waiving timelines that may otherwise apply for an emergency temporary restraining order and to allow Judge Medlock to retain jurisdiction under those terms.
Yes, sir.
Nobody has forced, threatened you, or promised you something other than the fact of what we've discussed on record here today.
No.
And it is your intention to abide by this agreement and enter this agreement subject to Judge Medlock's approval.
Yes.
Nothing further, Your Honor.
Counsel approach.
Ms. Noel, you read the documents that were filed by the state of Indiana, correct?
Yes, sir.
And there were some allegations that would make a casual reader believe that you were in the process of trying to sell automobiles or other assets.
Yes, sir.
You have never listed an automobile for sale.
No, sir.
You have never contacted a seller's agent.
No, sir.
You have never talked about selling anything, correct?
Correct.
You applied for duplicate titles to know what all was in your name or the family name solely without the view of trying to secret assets from the state of Indiana. Is that true?
That's true. Yes,
Your Honor, I hope that satisfies the inquiry.
State.
One moment, Judge. Nothing by St. Judge. Thank you.
Thank you, Your Honor.
Satisfied.
Joseph, would you stand, please? Or actually, come up here.
I was gonna say, why don't you get her closer to a microphone?
Young lady, please state your name.
Jamey Noel.
And you likewise are a respondent in this action filed by the state of Indiana.
Yes.
And you've read the documents filed against you.
Yes.
And you understand that you have certain rights and timelines that we've discussed.
Yes.
And you understand by entering the agreement that Mr. Stewart recited that we are waiving certain timelines and we are allowing by agreement that Judge Medlock, his honor, can retain emergency jurisdiction over this matter.
Yes.
You understand that you cannot sell any property?
Yes.
You cannot secret any assets?
Yes.
You don't intend to do that, do you?
I do not.
And we want to cooperate with the state of Indiana going forward to try to resolve this.
Yes.
And you wish the judge agree and enter the agreement as announced before the court.
Yes.
Nothing further for Joseph.
Just to clarify, because I don't know if it was explicitly said, you understand that the temporary TRO that is in place will remain in place until and unless a stipulated injunction is agreed upon or a hearing is held on the matter? Yes. Thank you, ma'am.
Thank you, ma'am. I apologize for omitting that. Come on up here, Gracie. Can I see you? Please state your name.
It's Gracie Noel.
And Gracie, you have been served with papers filed by the state of Indiana as well, correct?
Yes.
You've read those papers?
Yes.
And we've had an opportunity to discuss those papers. And you likewise are willing to waive timelines and hope that Judge Medlock enters the agreement as announced by Mr. Stewart? And part of that is you know that you cannot sell anything, you cannot hide anything. We have to make an adequate, honest, and forthright disclosure of of assets and debts.
Yes.
And you also know that the court retains jurisdiction over this until we have an agreement or a hearing is reached on this matter. And no one has forced you, threatened you, or otherwise made you do something you don't want to do today. Your Honor, that'd be all my questions.
Just to clarify, I know that you mentioned that it would maintain jurisdiction, but you understand also that that temporary TRO is in place until those things come to play. Is that correct, ma'am?
Yes.
Thank you.
Gracie, did you just graduate from school?
Yes.
Congratulations.
Thank you.
I know it took a lot of hard work. Next.
Casey, can you state your name, please?
Casey Noel.
And Casey, you understand that you're here because you've been named as a respondent in this present civil case, correct?
Yes.
All right, and did you hear the agreement that Mr. Stewart outlined?
Yes.
All right, and is it your wish to enter that agreement today?
Yes.
And you understand that the temporary restraining order that's been discussed will remain in place?
Yes.
And you understand that you will make a disclosure of all your assets?
Yes.
And you understand that we're waiving certain things like time limits and some jurisdictional matters due to that, correct?
Yes.
All right, I believe that's it, Judge.
Just to explicitly state, you understand that the court would remain in jurisdiction of this matter as an emergency status while this preliminary injunction matter is pending.
Yes.
Thank you.
Thank you.
Council approach. Is all parties satisfied with the testimony and stipulations and agreement that's been?
State as Judge Sanders.
Okay.
Yes, Judge.
Yes, Judge. Yes, Your Honor.
All right. Who's going to reduce it to writing for me and distribute it to all parties?
Plaintiff would be happy.
State will do that? Okay, very good. Is there anything else that needs to be addressed while on the record?
A hearing date. Oh, thank you.
Renee. June the 21st, Clark County at 1 p.m. Unless there's anything else, we'll be off record.
We have nothing for Mr. Noel, Judge.
Nothing from auto insurance, Your Honor. Thank you.
You're welcome, sir. All right, we'll be off record at 4:06.
Good evening, everyone. Absolutely. Thank you. All right, this is cause number 10, season 1, 2307, and C 1423, that being any matter by the Indiana State Police. Utica Volunteer Firefighters Association, doing business as New Chapel, Illinois, filed a petition or a motion to intervene on May the 23rd. And let that matter for hearing here at 1:30 this afternoon. Let the record reflect this now. 144, it's my understanding that the parties may have something of a resolution that they'd like to recite.
Yes, Your Honor.
Would you like to do so, Heather?
I can do that, Your Honor. Your Honor, we filed our motion to intervene to address property that belongs to my client that is currently in the possession of the state police. Mr. Hurdle and I have talked extensively over the last week. We would ask that that be continued out 90 days. In the meantime, we are working with the state police to have our staff go check out the 18 vehicles that belong to my client. They're in their possession, just make sure they're running, they're in good order. And then we're also going to work with the state police to find a storage unit that would be accessible only to ISP to maintain the care, custody, and control of the vehicles, but yet be undercover instead of, right now we're currently in an ISP lot that's chain linked. Their car has special car covers on them, but they're still outside exposed to the elements should the car covers come off. So I think that we can work on a resolution within the next 90 days, and then I would withdraw our motion after that period of time, Your Honor.
In the interim, you will not be getting access to anything that may be sealed.
No, Your Honor.
No prior notice of the search warrants.
No, Your Honor.
You gonna go get the refrigerator, the cooking unit, and HVAC?
If the state police and the prosecutor and the attorney general's office say we could do so, I'm sure that Chief Owen would make some kind of effort to go out there and get those.
Mr. Hurdle?
Thank you, Your Honor. I think Ms. Peters accurately described the agreement between the state and UDIC at this point in time. The state's not prepared to concede that they should be allowed to intervene, nor should there be a return of property at this point in time, but we're not going to get into the merits of the case as Ms. Peters suggested, and we're just going to ask this be moved approximately 90 days for some potential negotiation, as well as allowing them to review the property under the guidance and I guess supervision of the Indiana State Police. And at this point in time, we're not prepared to return anything at this point in time, as it's potential evidence of criminal conduct.
Understand. Well, not, I assume you understand that also.
Yes, Your Honor. We work pretty closely with the state police and the state board of accounts throughout this process. We understand.
Have any use for an $800 belt and a bunch of suits?
No, I don't think so.
Anything else?
No, Your Honor.
I think that's all, Your Honor.
All right.
Thank you, Your Honor.
Would you be so kind to prepare the entry for
I will,
tomorrow
Your
and send it to Mr. Hurdle for
Yes.
review and sign off on?
I will do so.
All right, we'll be off record unless there's anything else that needs to be addressed in this matter.
No.
Not from the state, Your Honor.
And it's my understanding the parties would like about a 5-minute break before we start the next hearing.
Yes, Judge.
All right, we'll be off record.
Thank you, Your Honor. Thank you.
We'll be back in about 5.
Oh, we didn't know you were finished.
We just got back. This one, right?
Yeah.
Hey, Lori, I think we're ready. Okay.
All right.
Welcome back. Thank you. All right, cause number 10, C01 2311 F5 297, State of Indiana versus Jamey Noel. Mr. Noel, this is your initial hearing on 6 new criminal charges. For the record, would you state your full name?
Jamey John Noel,
And your date of birth?
12/18/70,
That'd make you how old?
53,
And last 4 digits of your social security number.
2558, Your Honor.
What's your address?
3001 Old Tay Bridge, Jeffersonville, Indiana, 47130.
And are you under the influence of any drugs, including alcohol today?
No, Your Honor.
Read and understand the English language?
Yes, Your Honor.
If I say something you don't understand, will you let me know?
Yes, Your Honor.
I'll go through these counts.
Judge, before
Yes.
we go into the initial hearing, I just want to, for the record, I want to note an objection based on the statute relative to amended informations, specifically under subsection B2. I believe we're past the omnibus date. I think it's clear that the charges are additional counts, some of which alter defenses and/or evidence that might be adduced at trial. So I think it's clear that they tend to affect the substantial rights of the defendant. In that case, I just want to note that we believe that under subsection D, we should have been permitted adequate notice, an opportunity to be heard prior to the court entering an order on June 3rd accepting the charges. I understand the court has set this for an initial hearing, and I just want to note that.
State like to respond?
Well, a couple things, Your Honor. I guess first of all is there is a provision within the statute that allows for the amendment or the additional charges to be filed based on newly discovered evidence. As the court knows, and certainly the defense knows, this is an investigation that has basically continued on since probably June or July of last year. So almost 12 months of continued investigation. And many of these things were recently brought to light through search warrants through American Express, Sam's Club, and a number of other entities. So that newly discovered evidence allows for the additional evidence. Further, the state would show that we're not set for trial until November. This certainly gives the defense ample time to review the new additional charges, the newly discovered evidence, and time to prepare for a trial in November, which is 5-ish months away from now.
Mr. Stewart, anything you'd like to say in response?
No, Judge, I just want to note that the normal remedy would be, if done close to a trial, I do understand the normal remedy would be a continuance of that trial date. We're not saying that it's impossible for us to prepare at this time. It's hard to know depending upon what may be turned over in the near future. But again, I think under that subsection D, despite I'm not exactly clear where it says there's a basis that's solely about new evidence. I mean, there is a procedure to follow in every amended information. And subsection D provides that the defendant is entitled to adequate notice and opportunity prior to the setting of an initial hearing on that, and basically to address these types of issues. So,
well, and that may be partly the court's issue, Mr. Stewart, just in the interest of a judicial economy. Everybody was available and could get it done today. So you have a formal objection, feel free to file it. And if you need additional time to prepare for trial, I'm not opposed to granting that. Might want to talk to your client, see if there's anything else that may be discovered.
thank you, Judge.
All right. Count 26. I, the undersigned, do hereby affirm under the penalties for perjury as specified in Indiana Code 35-44-1-2-1 that between June the 4th, 2019 and August the 21st, 2023, in Clark County, state of Indiana, Jamey Noel did knowingly or intentionally acquire or maintain an interest in, receive, conceal, possess, transfer, or transport the proceeds of criminal activity and or conduct, supervise, or facilitate a transition involving the proceeds of criminal activity, and or invest, expend, receive, or offer to invest, expend, or receive the proceeds of criminal activity or funds that are the proceeds or funds of criminal activity, and the person knows the proceeds or funds are the results of criminal activity, and said proceeds or funds have the value of at least $50,000. It's a level 5 felony. Count 27. I, the undersigned, do hereby affirm, under the penalties for perjury, as specified in Indiana Code 35-44.1-2-1, that between June the 26th, 2019, and December the 31st, 2022, in Clark County, state of Indiana, Jamey Noel did knowingly or intentionally exert unauthorized control over the property of Clark County Sheriff's Department with the intent to deprive said entity of any part of its use or value of the property, said property having a value in excess of $50,000. That be December the 31st, 2019, 5 lawnmowers in the amount of $18,651.65, and or July the 20th, 2022, HVAC system in the amount of $6,539.12, and or June the 26th, 2019, a Dodge Ram in the amount of $11,000, and or December of 2022, shipping containers in excess of $25,000. Count 28. I, the undersigned, do hereby affirm under the penalties for perjury as specified in Indiana Code 35-44.1-2-1 that between March the 31st, 2020 and November the 29th, 2021, in Clark County, state of Indiana, Jamey Noel did knowingly or intentionally exert unauthorized control over the property of Utica Township Volunteer Firefighters Association with the intent to deprive said entity of any part of the use or value of the property, and the property having a value in excess of $50,000, that being child support payments in the amount of $50,968. Count 29. I, the undersigned, and these are all signed by Richard J. Hurdle. I, the undersigned, do hereby affirm, under the penalties for perjury, as specified in Indiana Code 35-44.1-2-1, that between December the 2nd, 2019 and January 21st, 2023, in Washington County, Clark County, state of Indiana, habit, Jamey Noel did knowingly or intentionally exert unauthorized control over the property of Utica Township Volunteer Firefighters Association with the intent to deprive said entity of any part of its use of its value of the property and property having a value in excess of $50,000. That being January 21st, 2023, a BMW in the amount of $21,000, and or May 1st, 2022, a 1957 Chevrolet in the amount of $40,000, and or August the 13th, 2022, a 1966 Pontiac in the amount of $33,919, and or January the 6th, 2020, a 1979 Pontiac in the amount of $20,000, and or December the 2nd, 2019, a 1966 Plymouth Roadrunner in the amount of $52,500, and or May the 20th, 2020, a 1970 Dodge in the amount of $45,000, and or July the 28th, 2020, a 1959 Corvette in the amount of $45,000. Count 30, theft, level 5 felony. I, the undersigned, do hereby affirm under the penalties for perjury or specified in Indiana Code 35-44.1-2-1 that between February the 17th, 2022 and May the 10th, 2023, in Clark County, state of Indiana, Jamey Noel did knowingly or intentionally exert unauthorized control over the property of Utica Township Volunteer Firefighters Association with the intent to deprive said entity of any part of the use or value of the property, and the property having a value of at least $50,000, that being May the 10th, 2023, an HVAC system at the Turnberry Mansion in the amount of $2,700, and or March the 22nd, 2023, chimney repair at the Turnberry Mansion in the amount of $11,200, and or February the 17th, 2022, airplane purchase in the amount of $25,000, and or September the 9th, 2022, airplane repair in the amount of $16,616.63, and or July the 13th, 2022, a Cub Cadet mower purchase in the amount of $11,000. Count 31. I, the undersigned, do hereby affirm under the penalties for perjury as specified in Indiana Code 35-44.1-2-1 that between November the 9th, 2023 and March the 29th, 2024 in Clark County, state of Indiana, Jamey Noel did knowingly or intentionally exert unauthorized control over the property of Utica Township Volunteer Firefighters Association with the intent to deprive said entity of any part of the use or value of the property, said property having a value in excess of $50,000. That being American Express credit card purchases in the amount of $37,151.40, and or Sam's Club credit card purchases in the amount of $15,667.16. These are all level 5 felonies. which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. You understand what you've been charged with?
Yes, Your Honor.
And do you understand the potential penalties?
Yes, Your Honor.
My next question is, usually you intend to hire a lawyer, but we've got a stable of lawyers, so I assume you intend to enter a not guilty plea, Mr. Wilder?
Yeah, Your Honor, at this time, Mr. Noel, how we wish to enter our plea this matter?
Not guilty, Your Honor.
All right.
Thank you, Judge.
I need to tell you, you have a right to a speedy public trial by jury in this county. You have the right to face all witnesses against you, see, hear, question, and cross-examine those witnesses. You have the right to have witnesses brought into court to testify on your behalf, and at your request, the court will issue subpoenas requiring those individuals to come into court to testify on your behalf or to bring evidence. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to remain silent. You cannot be required to give any testimony or make any statements against yourself to anyone. You do have the right to be heard in your own defense at any hearing or trial concerning the charges against you. Anything you say, however, may be used against you. Do you have any questions concerning your rights?
No, Your Honor.
All right. I'll enter the not guilty plea on your behalf.
Thank you, Judge.
Now, state of Indiana, with the issue regarding bond.
Yes, Your Honor. Given this matter is in the same cause number, the state believes that the appropriate statute for the court to consider is 3533.85, alteration or revocation of bail. And the state is asking for the court to alter his bail today. I think a couple of factors that the court should consider in determining whether or not to alter the defendant's bail today is that back in November, when we initially filed these charges and he had his initial hearing, many of these things were not known to the state at that time. Had the state known about these things, we probably would have charged at that point in time and probably would have affected the bail either request by the state of Indiana or the bail set by the court at that point in time. So many of the things that have now been charged either back with the 10 counts and now with these 6 counts were not known at the time. So I'd ask the court to consider that. I'd ask the court to consider also back at that November hearing when the same day that the initial hearing was, the defendant posted his bail that day. And part of his requirements that he not commit any new additional crimes. And if we look at the statute a little closer, bail can be altered, potentially even revoked, based on the commission of a misdemeanor or another crime. We have alleged through the state that he has committed 6 felonies. Probably the key one of those is count 31, which is the theft. And the theft that encompasses is what happened after the November 9th hearing to March 17th and March 29th. Because at that time, in that 3 or so month time span, maybe 4 months, the defendant is alleged to have used the credit card, American Express, as well as the Sam's Club credit card, both owned, operated by the Utica Volunteer Fire Department. So in excess of $50,000, approximately $52,000 was charged on those 2 credit cards as alleged in count 31. Commission of a new criminal offense can alter a defendant's bond, or at least the court can consider that. That combined with the contempt that the defendant had approximately 50 or so days ago when there was blatant disregard for the court's order to remove all weapons. The court obviously took that into consideration, but the use of these other credit cards is furthering this whole same entitlement, greed, lack of basically disdain for the court's authority. And so that's what the state believes is key in altering his bond today, and the state would ask you to alter his bond. So these additional crimes post-arrest are the key factors, and the other 5 counts also were not completely known at the time back in November when he was charged. So based on these factors, based on the statute set forth, and primarily, Your Honor, the 41-page probable cause affidavit outlined by Detective Heron, the state would ask the court to take judicial notice of that filed in this cause number.
We'll do so.
I'm sorry?
Court will do so.
Thank you, Judge. That is the evidence that the court needs to alter his bail. And the amount, the state requested a $25,000 bond at that initial hearing, and the court saw fit to set bail at $75,000. Based on his actions since November, the state believes that it certainly needs to be elevated at the court's discretion, but certainly a significant amount higher. Thank you, Judge.
Thank you, Mr. Hurdle. Mr. Stewart or Mr. Wilder?
Judge, I think again, I just want to note that the specific requirements and the alteration of bail is similar to the requirements to modify or amend a charge require adequate notice and opportunity. I mean, Vasendak, which is the case that prosecutors cite to hold people without bail until that hearing can be held, they have to specifically outline which pieces of the Indiana Code that we are alleging to have violated under the bail statute. Under Indiana, and I agree that we are under the exact code that Mr. Hurdle recited, but we're citing to specific sections that deal with alterations to increase bail, and then a separate section dealing with specifically outlined pieces relative to full revocations of bail. So I think that they're mixing two different pieces, and that's problematic because there's a different standard of proof that is specifically outlined in the revocation pieces of the statute, and it's clear and convincing evidence. And a probable cause affidavit, despite the fact that the court may agree that there's probable cause, that is a very low standard in comparison to clear and convincing evidence. So, I mean, that's the standard we use to take people's children away, not the standard that we use to, again, without notice, revoke somebody's bail. When you look specifically at the sections of the statute that deal with applications to the court for modifications for increase, what it notates is that if they present substantial evidence that indicates he is of high risk to not appear for court, or if they present additional evidence relative to new charges, that evidence, I mean, it specifically specified DNA evidence. Those are the times when you can increase bail. And I think that this process of trickling charges every couple weeks or months, it sets a bad precedent and it's bad policy to allow that to occur, because at this point, any prosecutor in the state of Indiana can file initial charges, wait a little bit, see if they like what the court's order is on bail, potentially defendant posts, file new charges that they knew of, and there are pieces of this that the prosecutor has known since prior to the First Amendment. So, and again, I do think that count 31 relative to the issues, is something that the court could consider, but it's an evidence-based process, and the standard is laid out for revoking based on a felony charge, and it's clear and convincing evidence that happened. So I'd ask that the court take judicial notice of the IRAS assessment that was done at the initial hearing. I don't believe any of the information contained inside that document has changed. Mr. Noel's ability and desire to show up for court has not changed, and there's been no evidence presented to the contrary. Thank you.
Thank you, Mr. Stewart. Question for anybody. Does Mr. Noel still have access to the Utica Township credit card?
No, Your Honor.
He hasn't for a lengthy period of time.
I'm sorry?
He has not for a lengthy period of time had access.
Your Honor, my client cannot confirm, we cannot get any,
Ms. Peters has no standing.
he said anybody who wanted to answer. I'm trying to answer.
Your Honor, I do not believe that at any point the court says anybody that wants to answer includes anybody sitting around that may or may not have involved.
All right. And I agree with that.
Thank you, Judge.
I'd like to call you as a court witness. You solemnly swear affirm under the penalties of perjury, testimony about to give will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
I'll see. For the record, tell me your name and your position.
Heather Peters, I'm General Counsel for New Chapel.
And I asked a question to the council out there, I guess not for the general public. You have a responsibility to your client in regards to whether Mr. Noel still has access to those credit cards. Can you enlighten me?
Your Honor, as to the American Express card, we did receive a notice in the mail from American Express that that account had been closed due to fraud, that there was a balance on it. We have not been able to receive any other information regarding that account. The Synchrony Bank, we have never had access to. Our chief, on my direction, had called Synchrony several times. We could not get information. That's why we filed a declaratory judgment action in Floyd. I guess it's in Clark County, but it's being heard by a Floyd County judge. So we have not been able to ascertain if that account's open, if there is a balance on it, and who has cards. I believe that Lieutenant Hearing at some point did get a copy of a card that was Misty's, maybe. I don't know if he has a physical card.
Good.
So we can have a say.
The one problem I have at this point is that Ms. Peters, who should know the rules of court, is turning to people and basically asking them to give her answers while
I'm
she's
not asking them
testifying.
to give me answers. I'm just acknowledging that.
Yeah, trying to confirm.
Right. You know, you can't
Yes,
ask anybody else to help.
Sure.
Has Mr. Noel used those cards lately?
Not to my knowledge. I did have a conversation with Chief Owen, and he has not seen any, and our accountant, he has not seen any charges come through in the last few weeks.
Counsel, like to inquire.
A couple questions.
You may. You may.
So, ma'am, the Amex card we're talking about.
Yes, Your Honor. Or yes,
No.
Mr. Wilder.
Never will that ever be something anyone will get to
You
say.
ain't got elected yet.
I will never run. Mark it down. So, the Amex account we're talking about, you're familiar with.
Yes.
And the Amex account we're talking about had cards issued to other individuals whose last names were not Noel, correct? Correct.
I have to think. Yes. Yes.
And one of the individuals was a fellow whose last name was Wilkerson, right?
Correct.
And it's already been determined and established through a State Board of Accounts audit that Mr. Wilkerson's credit card was used in a manner which was not consistent with the law, right?
I don't know that that was the exact wording of the State Board of Accounts.
The State Board of Accounts determined that there was $40,000 spent on the Amex card we're talking about.
Correct.
Right?
Correct.
And in addition to Mr. Wilkerson, there were other individuals who had Amex cards, correct?
Correct.
Mr. Owen had an Amex card, right?
Correct.
There are other folks whose names are on and who possess Amex cards that have the ability to use those right up until that account was closed, right?
Correct.
We don't see an itemization in this new charge of whom used this credit card and made what charges, did we?
In the information, I didn't review the information as they were filed. I've seen the credit card statements.
We don't know who used the card during this time frame and how much they charged, do we?
I know from looking at the statement, yes.
We agree. My question is simple. Of this $53,000 that is alleged that was spent, the Amex portion of that is whatever, because it's gone away on the screw. We do not know whether or not, based on the charge, those charges were made on a credit card of Mr. Noel's, do we?
I can't say that if you're asking based on the information because I haven't seen the information.
Synchronicity of it. What is it?
Synchrony.
Synchrony. Synchronicity is what we should all be experiencing, right? Synchrony. There were other cards issued to other folks from that account, wasn't there?
Yes.
So Mr. Noel's not the only individual who had access to a card, right?
Not on the Synchrony account.
Mr. Eubanks had a card? Mr. Wilkerson also had a card.
I don't know that.
Mr. Owen had a card.
Yes, I don't have a card.
So other people had a card, and that charge doesn't reflect whether or not the charge that Mr. Noel is facing, whether or not the number presented is just charges that are alleged he made, right?
I can't say that. I haven't seen the information. I just know what Judge Medlock read it. It was,
And we also know and agree that the American Express account was in fact guaranteed by Mr. Noel personally, correct?
that's my understanding, yes.
So had anyone defaulted on the American Express card, Mr. Noel would have personally been responsible for paying it, right?
In addition to my client, whose EIN was also listed on the account.
I've got further questions. Yes, thank you.
Mr. Hurdle?
No questions.
Mr. Eubanks had it?
Mr. Eubanks, I don't know,
Well, Mr. Wilder said Mr. Eubanks had a card.
and I don't know that. I don't know if he had a secret bank.
I'm looking forward to getting acquainted with Mr. Eubanks. Court has no further questions.
Thank you.
Thank you, Ms. Peter.
Anything else from anybody? Mr. Stewart?
I would just go back to, I think the court's initial question of Peters that she has no evidence one way or another. And the state hasn't presented any additional evidence relative to high risk for non-appearance. Or specifically DNA evidence tending to prove that the defendant committed some type of new charge that they did not know about at the time of filing of the initial information. And for those reasons, the specific subsection dealing with bail increases, those are the reasons. So, thank you, Joe.
Anything else, Mr. Hurdle?
Only briefly, Your Honor, with respect to the American Express card and who used it, who had it, while Ms. Peters may represent Utica, the criminal investigation conducted by the Indiana State Police, specifically Detective Heron, she's not privy to that investigation, who used what card, when, and as page 7 of the probable cause affidavit denotes, there's a credit card number with a specific name of Casey Noel, Utica Township Fire Department, listed on that. Had there been evidence that Casey Noel was continuing to use that credit card, there may have been additional charges on her. However, the allegation is that the defendant, Jamey Noel, in this cause is the one who has used that. Ms. Peters may not know exactly what the investigation entails, so I would ask the court to consider that as it's making its determination of who had which credit card and who was charging it. The allegation is that the defendant was using it with his card.
Mr. Stewart, anything else?
I think again, this, Judge, it's an allegation at this point, and it's information tending to demonstrate probable cause. Just an entirely different standard than the one that the court is required to consider for full revocations. Now, as to modifications or alterations and increases, again, similar circumstance where the probable cause is not the standard. So,
Mr. Stewart, I want you to know I have the greatest respect for your legal knowledge and knowledge of procedure. You're an intelligent path. I'm going to reiterate this again. I told Mr. Noel not to do anything stupid, not to deceive me, not to define me. He would not like the consequences. Didn't seem like you listened the first time. You released. And thus I sentenced you to 60 days for contempt. Your behavior since you were released seems to fit into all these categories. You know, I'm just a country boy from Washington County with a public school education. But when somebody warns me not to do something, I try to heed that warning because we say what we mean up there. So this is my analysis. With the informations and the affidavits that were filed, it appears that you had, or at least did have, an airplane, a train that was hidden, stable of exotic motor vehicles, a harem of women, at least 3 mansions, at least $3,000 suits, $800 belts, which you get personally delivered. I still seem to think that the Utica Volunteer Fire Department's your personal piggy bank. All the while, every day, individuals are trying to survive, working paycheck to paycheck. With their own money that they've worked hard for while you're out flung luxuries acquired allegedly at the expense of taxpayers. So with all these luxuries and all the money that you've allegedly taken, I'm thinking about $1.5 million in bond ought to be appropriate. Should be able to post that with no problems with everything that you have. If you don't listen to that, you post it, I don't know where we're going.
Judge, that increase by 1.5 million, or is it a total of 1.5?
Oh, you have that much in the bank, Wilder?
Judge, I was just trying to figure out my math over here.
We'll make it 1.5 even.
Thank you, Judge.
Shall we hold it until you go get it?
I would say Mrs. Wilder probably would have a question about that. Thank you.
Is there anything else?
Nothing other than
Mr.
that.
Stewart, I may be wrong, but my responsibility is to the citizens of Clark County and state of Indiana. And I think this is what must be done in order to continue to protect their interests and restore their faith in the rule of law. So
Thank you.
that's my order.
Nothing from the state, Your Honor. Thank you.
Be offered.
Former Clark County Sheriff Jamey Noel was expected in court this afternoon, but we learned this morning that his hearing was canceled. That hearing was about the Indiana Attorney General's case against him. The state of Indiana is suing Noel, saying it hopes to recover public money related to the criminal charges pending against him. We've learned agreements have been reached that resolve those hearings, but the results are confidential by order of the court. Noel is charged with theft, tax evasion, corrupt business practices, and ghost employment. Indiana has also asked a judge to freeze Noel's accounts and his ability to sell stocks and bonds or property. Noel is currently in jail on a bond of $1.5 million.
Another hit for the embattled former Clark County Sheriff Jamey Noel. His wife filed for divorce today.
And that's not all. New search warrants tie a current Clark County councilman to Noel's alleged lavish spending. Lindsay Allen here tonight to walk us through all of it.
Yeah, guys. Well, first, the divorce petition. Misty Noel claims that her marriage is irretrievably broken and says the couple has been separated since April. Jamey Noel will be served at the Scott County Jail, where he remains on a $1.5 million bond.
This is, are we on, Laura?
Yes, sir.
10 C01 2403 F6 230 State of Indiana versus Casey Noel. I've had several motions filed. It was last Friday, Sana.
Judge, I think I initially filed several motions on Thursday. They were followed by more motions on Monday and some yesterday.
All right. So we'll take up some of those motions. All right. There we are sitting here at the moment. So, Sonny, would you like to argue?
I would, Judge. I would, if the court would allow. I know we're here for several matters, most of which were filed by me. I'd like to begin by arguing my motion to continue Casey's jury trial. Does that please the court?
No objections.
Thank you, Judge. Judge, I primarily filed this motion to continue because the present course of Casey's defense did not present itself until it became clear that Jamey Noel would not be returning to the family home at the beginning of June, and that instead he would remain incarcerated in the Scott County Jail. Since then, with Casey and her mother and her sisters away from Jamey's physical presence and his physical control, a much clearer picture of the control and the manipulation and the relationship that he had with his immediate family has emerged. As I began to realize that during the month of June, after Jamey remained in Scott County, I started looking for an expert in the area of coercive control. Coercive control is essentially a pattern of controlling behavior and abusive, manipulative behavior that can change the way that a person processes information and change the way that they're able to respond when that person tells them to do something. And I think it's very important here. Judge, I was able to find Dr. Lisa Fontes, who is an expert in that area from the University of Massachusetts, and I engaged with Dr. Fontes in July of this year. I believe that Mr. McMahon has also engaged with Mrs. Dr. Fontes on behalf of his client, Misty. Judge, I disclosed that she was going to be an expert in this case formally last week. I'm asking for a continuance so that Dr. Fontes has the time that she needs to get into this case, to look at the evidence, to look at the types of communication that Jamey had with his family, with his daughters, with his wife, and to look at the ways that he controlled and manipulated them and what their life was like. I'm also asking for a continuance for another related reason, Judge, and that is because in the past week or so, I have received additional discovery from the state of Indiana. On July 31st, there was a discovery disclosure filed into Casey's case. I believe that the information in that disclosure will be forthcoming from Mr. Hurdle. I do not have it yet. However, I know that it does involve some recent search warrants that name Casey, and it's clearly very important that I get that and I'm able to review it. But secondly, Judge, and perhaps more importantly, I requested at a status conference in Washington County that I be provided with all of the jail phone calls that Jamey Noel has made while incarcerated in the Scott County Jail. I'm entitled to those as a piece of discovery. The state police are listening to them. And Sunday, 2 days ago, I began to receive those calls. The format that I'm receiving those voluminous calls in is that I'm getting forwarded emails from the Scott County Jail. Attached to each email are approximately 3 telephone calls. And so far, I received probably 250 emails. So 250 times 3 are the number of calls that I believe I have right now. Due to that formatting, I'll need to download those calls, organize them, and before I can even begin to understand what they are or how to use them. I also think that those phone calls are going to be some of the most important pieces of evidence for Dr. Fontes to review in her evaluation. So those things are very important to me, Judge, and I'm here to ask for a continuance, not for the sake of delay, but so that I can present for Casey the best defense that exists. And that's what I'm here to do today, Judge. That's why I filed the things that I filed and why I'm asking for this continuance. As the court is aware, I also filed, among my other filings, a request for a discovery deadline. Judge, we know this investigation is ongoing. I know the state police continue to do search warrants. I know they made some calls regarding Casey's case last night. And all of these things result in additional discovery. And additional discovery forces me to ask for time to review that. I don't want this to be something that continually happens, Judge. And so today, I'm asking for a discovery deadline prior to the trial date so that there is a cutoff for the state of Indiana to provide discovery to me that I have to review and prepare to defend. Judge, I think it's important that we realize that at some point, the investigation has to cease and a resolution must be had. That resolution can be had in several different ways. It can be a trial, it can be via negotiations, but these charges were filed in March, and this is not a situation on behalf of Casey, because she shares my thoughts on this, that we want to continue indefinitely. We want this wrapped up one way or another, Judge, and I'm here to ask that her case be set with Misty Noel's case in October, which is, I suppose, approximately 2.5 months away at this point, and we have a further motion to order regarding joinder.
Ms. Bush-Saltel, at our status conference in Washington County, I indicated that I would not be inclined to continue the trial date unless there's significant movement on one or both sides. I haven't heard that there's significant movement one way or another. So why did you wait so late to retain the expert?
Judge, movement as far as negotiations?
Yes.
Judge, I would note
Not that I'm entitled to know the state of the
I
negotiations.
understand. I'm happy to give a brief outline and to discuss that. Judge, there has been some movement regarding negotiations. There have been some further conversations. I did make Mr. Hurdle aware that the expert would be forthcoming. However, there is a process that governs us right now through the Attorney General case regarding any money that may be spent for Casey's defense. So there's a process I have to go through to make the Attorney General aware of any requests that I'm going to be making. So everything in that case has the ability, to some extent, to delay the things in this case because we are working very cooperatively with the Attorney General regarding that injunction.
Okay, but apparently they've authorized you to expend funds to obtain this expert witness, correct?
Judge, I have sent the request to them. I would leave it at that for now. Some of our negotiation discussions with the Attorney General are confidential. I'd not want to violate that.
I understand.
But I would stay on the record that Dr. Fontes has agreed to be our expert in this case as well as Misty's case.
Mr. Hurdle.
Your Honor, with respect to the motion to continue, candidly, the state has no objection to the continuance. The state, as well as the defense, I think, doesn't want to prolong this case indefinitely. I know the court doesn't either. If the court told us we had to be prepared, we would be prepared. Maybe as the court had mentioned before, Casey Noel and Misty Noel's case maybe is not quite as complicated as Jamey Noel's is, dealing with tax issues as well as the expenditures on the American Express card. But we do see some value in moving this and allowing for the continuation of discovery. The state would have serious concerns, though, about trying to try this in a couple of weeks, given the fact that an expert for the defense was just disclosed and a defense of sorts is being, I guess, proposed at least to the court and to the state right now with Dr. Fontes. And I think the state was going to need some time to at least maybe depose her or at least have a informal conversation with her, whether that be via Zoom, whether it be telephone or in person or all the above, I don't know. But having just received her name last week puts the state in a bit of a bind. So with that, the state has no objection to the continuance. And just, I know Ms. Bush discussed the discovery deadline. You know, all due respect, the defense wants and is entitled to what we're finding in search warrants, in interviews, and everything else, because some of it may be exculpatory and some of it may not be exculpatory. They may not realize that my duty is anything exculpatory has got to be turned over because of Brady. And if I don't, then I'm subject to ethical violations and etc. So I think for the court then to cut off all discovery puts me in a trick bag that if I get something, say a jail call, say Jamey Noel makes a phone call that is exculpatory to Misty Noel or to Casey Noel, and are we saying, okay, you can't turn that over, Mr. Hurdle. Discovery deadline's passed, we're finished. And it's something of significance to them. So it's as they want to maybe have their cake and eat it too. You want this information, but you want the deadline nailed down also. So I'm not sure what the result is, but I feel like I have a duty to turn this over, and I will continue to turn it over until the court says, Mr. Hurdle, stop turning things over. And I don't know that that ever ends, as long as it's potentially exculpatory. So I know those were the two things that Ms. Bush brought up in her argument on the continuance and then on the discovery deadline. I don't believe we got into the motions in limine or the joinder at this point, but I'll address those as they come.
Mr. Hurdle, there's been 67 search warrants, which is a large number of search warrants for a particular matter. And I've signed all of them, and I'm aware that the last several have mentioned Casey Noel as someone you're seeking information about. And I don't know whether you've got that information or not. Is there possibilities that there may be additional charges against Casey Noel?
Your Honor, in complete candor to that, I don't know. There have been discussions with the state, as the prosecutor's office, with the Indiana State Police, saying, guys, maybe we need to turn this spigot off at some point in time and say enough is enough, and we play the hand that we're dealt right now in a very figurative sense, that we deal with the charges. But there is a little bit of an obligation that I think the state police believe, as well as the state of Indiana, the prosecutor's office believe, that if we're presented with potential additional criminal charges, do we have a duty or responsibility to file a criminal charge based on those? I know that's a long way getting to what your question was. Are there going to be additional criminal charges? The answer is I don't know. I think it depends on what these warrants or what information still can surface at this point in time. And while the case itself may not be super complicated, there are enough layers here that there are things that have been hidden by the defendants that the state has not uncovered at this point in time, and there may be still some uncovering at this point in time.
Ms. Bush-Saltel, would you like the last word? Excuse me.
Thank you, Judge. And I would just note that Mr. Hurdle used the phrase, turn off the spigot. I think with my motion for a discovery deadline, and exactly what that looks like, I think we could discuss. But right now, Casey's been charged since March. No further charges have been filed against her since March. I am preparing for a trial, Judge. I'm retaining expert witnesses. I'm preparing to schedule depositions. And my request, just as Mr. Hurdle put it, is to turn off that spigot in some way or another so that we can proceed. Thank you.
Mr. Hurdle mentioned something about the court saying we're going to have a trial, get ready. Well, I denied the motion to continue summarily last Friday, indicating that I wanted to hear further argument in regards to that matter. And as requested, I got the motions in limine and the proposed preliminary instructions, and I appreciate the prompt response. So, since the state does not object, I will grant a continuance. I'm not sure how long, and I don't know whether it'll be at the same time as Misty's. I want to hear your arguments in regards to joinder. So
Judge.
You may proceed.
And Judge, if it would please the court, Mr. McMahon and I have filed nearly an identical motion in Misty Noel's case and Casey Noel's case regarding the joinder. We'd ask to argue those together to expedite the court's time and Mr. Hurdle's time and the time of the witnesses and everyone present today.
Any objections, Mr. Hurdle?
No, Your Honor.
Mr. McMahon, any objections?
No, thank you, Your Honor.
So whoever would like to proceed.
Judge, I'll proceed since Misty was a defendant before you before Casey was. As the court is familiar, and actually we are in the state is, the allegations against both Casey and Misty, we have failure to pay income taxes related to the allegation that there were abuses of the New Chapel American Express card where purchases were made and they were not claimed as income and were unauthorized, is what the state alleges. That is what we have with these two women. And it's the same American Express account. The only difference between the cases are that we have two defendants and we have different sets of income tax returns that will show what was claimed, what was not. Otherwise, the American Express statements are the same for each. And the most compelling reason for joinder, Your Honor, I think, is to ease the burden on Clark County, Indiana. I'm happy to be an attorney who appears in Clark County regularly, and knowing the notoriety of this case, finding 2 juries is going to be difficult. I don't know how many jury summonses will go out. You know, typically in a high-profile case, 150 go out by my experience in this area. Last time I had a high-profile jury trial was last year in Floyd County, Indiana, and 150 summonses went out. I would expect it would be more so here because we have the Noel name attached to it. That's significant. And Your Honor is aware that Jamey Noel was a respected law enforcement officer, future sheriff, and more importantly, the chair of the Republican Party for the 9th Congressional District here in Indiana. So his name is recognized substantially. And when we consider judicial economy, it's the idea of saving the state, the taxpayers, the community, the burden of having 2 trials when one would suffice. I would expect that if you join these 2 cases, Your Honor, a 4-day trial for Misty or a 4-day trial for Casey may turn out to be a 6-day trial for both. And it eases the burden on this court staff, Your Honor, who travels from Washington County, Indiana, and also for the defendants. And we know that we are sacrificing something by asking for this because we have to combine our jury strikes, things of that nature. The only complicator would be, insofar as Misty is charged with a level 5 felony, she's entitled to a 12-person jury, whereas Casey, looking at level 6 felony, she would get a 6-person jury. And I think that's something that could be resolved on the back end by agreement, or I imagine that bridge has been crossed somewhere, although I've not researched it yet, Your Honor. But looking at joinder, there's one person who has the discretion to say yes or no, and that's you. You are able to say, yes, I'm going to do this, or no, I'm not going to do it. And it's a discretionary call, and it's one that the facts of this case support it, right? Because the charges are so alike. It is out of the same PCA and search warrants that the state is following against Jamey Noel. They are, for lack of a better term, derivative defendants in that investigation. And the proof overlaps so much, it's hand in glove. We think that joinder is proper. Thank you, sir.
Mr. McMahon?
Yes, sir.
You brought up one point that was of great concern to the court, that Misty has level 5 felonies and Casey has level 6 felonies. I don't disagree that they're charged with similar offenses, except they occurred on different dates and times and for different purposes. I'm not sure exactly how to make it fair to either one of them by joining them, with Casey's being a level 6, which is a 6-person jury, and Misty's being a level 5. I don't disagree that the state's probable witnesses are the same, but they were not charged as co-defendants at the same time. So that's some of the court's concern. Can you help alleviate that?
Judge, the simplest solution to that concern, I think, would be that the court and panel, 6-person jury and a 12-person jury. You have a Misty Noel jury, you have a Casey Noel jury, because otherwise the state and or Casey Noel would have to agree that a 12-person jury would be proper for Casey Noel's case. And I know that that's unique, it's different, but I do think that that would still serve judicial economy and serve the interests of Clark County, Indiana, as far as the cost and the expense, and also make it easier to suit a jury in these cases. Because once you have one trial, I'm looking at our friends from the media, and I'm counting 4 cameras right now, it's going to be harder to set a second trial. And so I do think that joinder makes sense in this regard, Your Honor. And how we solve that problem is something that we would have to look into and try to do that. And I hope I've answered your question. I'm not trying to be flippant or smart, but it's a unique issue, as you just mentioned. Thank you.
Well, and I give you credit. I think that's an innovative idea. I'm not sure it's allowed, but we'll find out. I'll consider it. Mr. Hurdle.
Your Honor, I mean, joinder for trial purposes means the same jury. The second proposal, while innovative as it may be, the state believes that's a mess. If we're going to seat one jury to listen to Casey, 6-person, a 12-person to listen to Misty, are they supposed to talk amongst each other? Are they allowed to talk amongst each other? Are they going to deliberate together? Are they not going to deliberate together? The state believes that is a disaster, right, for any appeal purposes down the road. The state would certainly object to that. The other issue is whether or not 6-person or 12-person, whether one of them would waive the 12-person, Misty, or whether Casey would waive or ask the court to allow her a 12-person, is something the state would need to consider. I don't know at this point in time, in complete candor again to the court. I know the court has brought this up. Mr. McMahon now has brought it up as well. A level 5, a level 6, two very different, at least in the state of Indiana, jury pools, and 6 versus 12. And the way it was set up, whenever it was 6 versus 12, was done for a reason. And I don't know that I want to be the test case for a waiver of that. So I guess, Your Honor, the state would ask for a short period of time, whatever that may be, to look into this issue, 5 versus 6 level felonies, 12-person versus 6-person. And I'll just leave it at that, Your Honor. But the state is certainly not prepared to agree to 2 separate juries hearing this case, because I believe that's logistical a nightmare.
Mr. Hurl, how much time would you like to request to research that issue?
Your Honor, a week or less.
So, counsel for defense?
Judge, I think today is Tuesday. I think if we could have an answer to the court next Monday, that would be appropriate.
Mr. McMahon?
Judge, that's agreeable. Thank you.
Thank you.
Perhaps it might make sense, Judge, if the court would like, to set a telephonic status conference or something to that effect next Monday to discuss with all parties.
Well, I'll give you till next Tuesday at noon. That'll give me time to look at it, and then we can have a telephonic status conference sometime shortly after that.
Thank you, Judge.
Thank you, Judge.
You're welcome. Ms. Bush-Chantel, do you have something else?
I do. I have more, Judge. First, I would address, per the court's order on Friday, I complied. I filed several motions in limine. I filed preliminary jury instructions. With the courts granting, at least to some extent, my motion to continue Casey's trial, I would request that a further date be set to hear those, as well as any additional that may be filed due to the recent discovery. Is that agreeable to the court?
Mr. Hurdle?
Your Honor, as long as the state may have an opportunity at some later point in time to either object or agree to the motions in limine that the defense has filed, I no objection, just moving that to the next hearing date that we have prior to the trial.
And that is my request, Judge. Not to have them granted today, but to leave them pending and set them for another date.
That's fine.
All right, and I believe the last thing that I have pending, Judge, that I filed recently is a motion to slightly modify the terms of Casey's bond. And Judge, if the court is aware, since March, Casey has had a term for bond that she must remain in the state of Indiana. There have been no violations of that. There have been no violations of any sort of Casey's bond. However, Judge, I'm asking to modify that slightly for several reasons. The first of those is that Casey and her mother Misty and her sister Gracie are all employed here locally full-time. They have varying hours. Sometimes Casey works late, sometimes she has to be there earlier, the same for her mother and sister. And as I stated before, we are working under the Attorney General regarding some things, regarding assets and those sorts of things. And currently, the 3 ladies are sharing 2 cars. Gracie currently works in Louisville, Misty and Casey work here in Indiana. However, they've had to work out a schedule to pick each other up, drop each other off, all of those things. And it would greatly ease the strain on the 3 of them If Casey were able to drive to Louisville to pick up Gracie, to drop off Gracie, to do those sorts of things surrounding their employments and the ways that they're having to work together, considering the current order from the Attorney General. Secondly, Judge, and perhaps more importantly, yes.
One moment. So you're telling me out of the hundreds of cars that was under the control of the Noel family, I guess, there's only 2 left?
Judge, there are 2 cars that are the type of cars that Misty Noel, Casey Noel, and Gracie Noel are comfortable driving. They have no desire to drive around in Jamey Noel's collectible car collection. They would not be comfortable doing so. It would not be appropriate to do so.
Why?
Judge, I think the women of the Noel family are attempting to avoid public attention and public scrutiny. And also many of those cars, Judge, are old cars. They don't know if they're functional, those sorts of things.
Proceed.
Thank you,
Continue.
Judge. And secondly, and again, perhaps more importantly, due to the geographic nature of our area, our larger metro area is Louisville. Our health centers are there. Our hospitals are there. Our mental health services, many of them are located in the Louisville metro area. Casey has need of mental health services and health services. And being able to go to the Louisville metro area would greatly open her ability to have access to more providers and more specific providers. And so primarily, I am asking that the bond be modified for that reason, Judge. And I would ask the court to note that due to the geographic nature of our region, many people who are charged in southern Indiana actually live in Louisville. I believe, due to my practice in other surrounding counties, that all of the counties that run along the river have bond terms that allow people to at least go to the Louisville metro area due to that. And so I'm simply
Ms.
asking.
Bush, I'll
Yes, sir.
tell you, I don't care what other jurisdictions do. No consequence to me. So you might as well forget that argument.
That is just fine, Judge. I was done with it anyway. And so, Judge, I'm simply asking for that slight modification. It's certainly at the court's discretion whether to grant it or not. I saved it for last today because I do believe it is the least important thing that we had to address here, but wanted to put it in front of the court. Thank you.
She won't be going to any Irish pubs for celebration?
That would not be the intent, Judge.
Mr. McMahon?
Thank you, Judge Medlock. I filed a similar motion on behalf of Misty Noel, and it's one she's been a defendant for about 7 months right now, Your Honor, and there's no allegation that she has violated bonds whatsoever. I think she's shown proper respect to the jurisdiction of this court.
I have no reason to doubt that, Mr. McMahon.
It's one she works here in Clark County, Indiana. The court's been gracious enough to allow her to visit me in my office in Louisville without having to ask for permission, because the court noted that gets into the Sixth Amendment privilege that she has quite a bit. And Your Honor's also allowed her with approval to go to Louisville for medical appointments. This is one of the most unique cases I've ever been involved in.
And go to her daughter's celebration.
And Judge, we do not thank you enough, because that was very important for the family under a hard time. And thank you, sir. And I did not mean to make short shrift of that or not acknowledge that, sir.
Well, I thought it was important that she be able to attend.
And the family values that, Judge. Thank you. The Noel family lives in a bubble here in Floyd, Clark, even Harrison County. We're not asking for a party pass under any circumstances, Your Honor, at all. It's just to take care of Gracie, and I think the court is aware that she is a child inspector, and to make sure that she's okay, because if there is an issue, we need to help her. And I know that because I have an autistic child. It matters to be able to take care of her. And this family loves Gracie very much. They want to take care of her and make sure that she has that invisible safety blanket that she needs. And Judge, we're not asking for to go to sporting events, to go to parties, to go to bars. It's just to be a regular person. And we understand but there are terms of bond. These women have posted their bond. Misty has done so. And if anything, they want privacy. They want a quiet life, because if they were to go to dinner tonight at Texas Roadhouse off Veterans Parkway, people will take their photos. That happens to them. They have no privacy. They are a spectacle wherever they go. And so they are living in isolation within their own community. They get a little bit more anonymity in Louisville, but I'm not asking that they're allowed to go and live as though they're on spring break under any circumstances. And the other point I would like to add, Your Honor, with regard to the automobiles at the pole barn, I had the pleasure of touring the pole barn a couple of months ago. There's a 1959 Cadillac that does not have a door handle to open it. There is a antique Clark County Sheriff police car. All of these are hot rods. It is something that looks like later in life somebody who loved Hot Wheels and Matchboxes were able to buy them. They're not functional cars. We've asked the Attorney General for leave to purchase a car so that there's more reliable, modest transportation. And we're just asking that they have a little bit of liberty for the purpose of the family. And that's it, Judge. We don't want to create a spectacle or show disrespect to the court or the state of Indiana. But I think that these women have lived in public scrutiny that is unusual, and it's one that they want to make sure that Gracie, who works over in Louisville, has the safety net that she needs. And that's the nature of the motion, Your Honor. Thank you.
Mr. Hurdle.
Your Honor, the state is not without empathy toward Misty or Casey or Gracie. And I know that the court is not either. If there are doctor's appointments, if there are medical issues, if they need to see their attorney, or there's some other issue other than Gracie's work that the court would deem appropriate, the state's position would be file the motion, let the court make that decision. Now, I'm not trying to bombard the court with motions to go to and from Louisville, but how often are doctor's appointments? How often are dentist appointments, chiropractors, things of that nature? I wouldn't think that many, and the state certainly is not going to object to those situations, much like it didn't object to the family going to Gracie's event in Louisville when it was a work situation. I would point out to the court that on 3/18 of this year, the court issued an order clarifying terms of bond. Defendant shall remain in the state of Indiana. Defendant shall not consume illegal drugs or alcohol. That the defendant shall not consume or commit any new offenses. Restrictions were not mentioned in defendant's initial hearing, and without the court's knowledge, did not appear under bond form. Additionally, the court may consider permission for the defendant to leave the state upon request by the defendant in writing. And I think that was done as to avoid this issue here of the back and forth to Louisville at a whim. And so the state would ask the court to kind of follow those original conditions of bond. And if there are issues that come up, then we deal with those. Maybe if they're that often, then we deal with those via Zoom or a conference call or something like that. And I don't think the state's going to stand in the way of those certain things. I would point out that both defendants do work in the state of Indiana. This is a benefit for younger sister or daughter Gracie, and while she may need some assistance or help, I don't know, without knowledge, whether or not she has a valid driver's license. I know that there was a graduation recently from a university, so I don't know what limitations are prohibitive of her being able to go back and forth if she has a valid driver's license. But bond is supposed to be restrictive, and it is restrictive on those two. The fallout is on younger sister or daughter. But that's because of this position that they have put the court in and themselves in, nobody else. I'd ask the court to consider that.
I'm not unsympathetic to Gracie, as Mr. Hurdle said. I'm quite sympathetic. And I also agree with Mr. Hurdle that these ladies they made decisions that brought themselves here. And there has to be some type of restraint. Counsel, if you will file with the court the list of automobiles identified by make, model, and year that they have available to them, and the vehicles they currently utilize for transportation, and under seal where they would be going to in Louisville. I'll review that and then make a decision.
Thank you, Judge.
In regards to the scrutiny and getting their photographs taken, well, they're not the only ones that happens to. It seems to happen to me on a fairly regular basis. It's my understanding that some scammers are now using my name to try to collect funds from unwitting citizens. So, we're all under scrutiny. Anything else, Ms. Bush-Sawtell?
Judge, I believe that concludes everything that I had filed for today's date.
Mr. McMahon?
Nothing else, Your Honor. Thank you for giving us your attention today.
Mr. Hurdle?
Your Honor, the issue of the continuance, that it's taken under advisement as far as a rescheduling date at this point in time, and the discovery deadline will also be taken under advisement as well, Your Honor?
It will.
Okay, that's all I have.
Once we determine what the new date will be and or whether it's going to be joined, then we'll establish those dates and times. Unless there's anything else, we'll be off record.
I'm sorry, Your Honor. The time for the filing or position of the parties on the joinder will be noon next Tuesday?
Yes.
And is that something that we will handle via phone call to your office, or are we to come back here?
I would prefer that both parties, all three parties, file a brief with the court, and then we'll have a discussion after that.
Okay, thank you, Judge.
Depending on the arguments that are made. I don't know that I necessarily will require an additional hearing, but I would like your supplemental arguments filed with the court by next Tuesday at 12.
Thank you, Judge.
Anything else?
No, sir. Thank you.
Okay, we'll be off record. Thank you all.
Rick.
No, of course, we'll certainly go through that. I expect this is nothing good. Yeah, that's
Several weeks ago, the fourth civil action was filed against Jamey Noel. This one by his nieces and nephews related to the estate of his deceased brother, William Leon Noel. They're alleging that Jamey Noel, as personal representative for the estate, sold his brother's home located in Jeffersonville to his daughter, Casey Noel, for $180,000, despite the property being worth more. After the mortgage on the home was paid, $112,000, closing expenses were deducted, and defendant Casey Noel was gifted $36,000. A check in the amount of $25,545.78 was issued to the estate of William Leon Noel. Defendant Jamey Noel then deposited the check into the estate checking account at Fifth Third Bank. Defendant Jamey Noel, as personal representative, did not reimburse the estate for the $36,000 in equity that he gifted his his daughter, thereby depriving the plaintiffs of part of their rightful inheritance. Jamey sold another home for just under $120,000, depositing that money in the Fifth Third bank account. Jamey Noel, as personal representative, wrote a check from the estate account to Paul Lockhart Construction in the amount of $8,000 for basement work on the property prior to the sale. He paid Paul Lockhart Construction another $8,232.30 via a PayPal account that was linked to an American Express account for the Utica Township Volunteer Fire Department. On May 29, 2019, defendant Jamey Noel wrote himself a check for $16,000 from the estate bank account to reimburse for basement work on the home, despite having actually not paid for any of the work. Defendant Noel improperly paid himself that $16,000, depriving the plaintiffs of part of their inheritance. In October of 2019, as personal representative, he filed a verified closing statement with the probate court asserting that all assets had been collected, deeded, administered upon, and were ready to be distributed to the heirs. The verified closing statement also asserted that the personal representative had provided all statutory notice to all interested parties along with a copy of the closing statement. However, the plaintiff never received any paperwork concerning the estate or any asset therein from defendant Noel. In October 2019, Noel distributed $30,000 to his nephew. Then in December, he took $52,000 from the estate and didn't give them anything. He went and bought a 1969 Plymouth Roadrunner. Then in December, he wrote checks to the remaining two children of his brother, totaling $36,000. However, those checks bounced due to insufficient funds. In January of 2020, Noel took $52,500 from the Utica Township Firefighter Association bank account and deposited it into the Noel estate checking account. And then he obtained 2 cashier's checks for his niece and nephew. Wow, this guy is a total piece of garbage. A 5th lawsuit was filed civilly against Jamey and Misty Noel. This one by the Board of Fire Trustees, Utica Township Fire Protection District, and it was also against the Utica Township Volunteer Firefighters Association, doing business as New Chapel Emergency Medical Services and New Chapel Volunteer Fire Company. This is an attempt to recover some of the funds that Jamey Noel so kindly dissipated.
A joint motion in tender of conditional negotiated plea that purports to be signed by you. Is that your signature?
Yes, Your Honor.
Now, before I can accept a guilty plea, I must be satisfied you fully understand your constitutional rights, that your plea of guilty is being made freely and voluntarily, and that you've in fact committed crimes. Therefore, it would be necessary to ask you certain questions and hear some evidence. If you don't understand the questions that I ask or the words that I use, please let me know and I'll try to explain them to you in a manner you can understand. Feel free to speak with your attorneys at any time. For the record, state your full name and age.
Jamey John Noel, 53 years old.
You ever been treated for any mental illness or emotional disability?
No, Your Honor.
To the best of your knowledge, you now suffer from any mental illness or emotional disability?
No, Your Honor.
Are you under the influence of any drugs, including alcohol, today?
No, Your Honor.
You read and understand the English language?
Yes, Your Honor.
And it's my understanding that you wish to withdraw your previously entered plea of not guilty and enter a plea of guilty pursuant to the terms of this document.
Yes, Your Honor.
I need you to understand you have a right to a speedy public trial by jury in this county. You have the right to face all witnesses against you, see, hear, question, and cross-examine those witnesses. You have the right to have witnesses brought into court to testify on your behalf. And at your request, the court will issue subpoenas requiring those individuals to come into court to testify on your behalf or to bring evidence in. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to remain silent, cannot be required to give any testimony or make any statements against yourself to anyone. You do have the right to be heard in your own defense at any hearing or trial concerning the charges against you. Anything you say, however, may be used against you. Do you have any questions concerning your rights?
No, Your Honor.
And do you understand that by pleading guilty, you're going to give up and waive each and every one of those rights?
Yes, Your Honor.
And if you were to have a trial and you were to be found guilty and sentenced, you would have a right to appeal your conviction and or the sentence to the Supreme Court or the Court of Appeals. Do you understand that?
Yes, Your Honor.
And do you understand that by pleading guilty, you're going to give up and waive that right also?
Yes, Your Honor.
And you understand these convictions may be used against you in the future to enhance a charge or to enhance a sentence.
Yes, Your Honor.
Level 5 felonies have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. Level 6 felonies have a range of imprisonment of no time in jail if it's treated as a misdemeanor, to 2.5 years at the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine. Do you understand that?
Yes, Your Honor.
Anybody offered you anything of any value to get you plea guilty here today?
No, Your Honor.
Anybody threatened you, coerced you, forced you, or anyone else to get you to plead guilty here today?
No, Your Honor.
When you were charged, were you out on probation, parole, or on a suspended sentence?
No, Your Honor.
Were you out on a bond on any other case?
No, Your Honor.
And you've been represented by very competent counsel throughout these proceedings, correct?
Yes, Your Honor.
Satisfied with the advice of counsel and the outcome of the case?
Yes, Your Honor.
I'm not saying I'm accepting this. I'm not saying I'm not. Because this is a level 5 felony, the court is required to have a pre-sentence investigative report before you can be sentenced. You understand that?
Yes, Your Honor.
Mr. Wilder would like to establish a factual basis. Mr. Noel, would you stand? Raise your right hand to the best of your ability. Do you solemnly swear or affirm under the penalties for perjury testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You'll take a seat at the witness stand, please. And Mr. Hurdle, the way I traditionally do it is I have defense counsel do a factual basis and then give the state an opportunity to ask any follow-up questions they may ask.
Thank you, Judge.
Thank you, Judge.
Mr. Wilder.
Mr. Noel, you've been previously sworn, correct?
Yes, sir.
And you're here today to change your plea that you originally entered in this case from not guilty to guilty, correct?
Yes, sir.
Prior to today, you've met with your attorneys.
Yes.
We have met and explained each charge that has been filed against you.
Yes, sir.
We've explained the possible minimum and maximum penalties for each of those charges to both your freedom and your finances.
Yes, sir.
We've also explained the difference between consecutive sentencing and concurrent sentencing.
Yes, sir.
We've explained to you that there's a potential that if you were to go to trial, found guilty, that you could be sentenced consecutively as well as concurrently as some of the charges, right?
Yes, sir.
And we met throughout the time this case was pending. We reviewed the discovery provided by the state.
Yes, sir.
We reviewed thousands of pages of financial documents.
Yes, sir.
We reviewed a multitude of documents that were related to vehicle transfers and purchases.
Yes, sir.
We were provided hours of taped statements of witnesses.
Yes, sir.
We listened to those statements.
Yes, sir.
And we, in addition, have written transcripts that we reviewed.
Yes, sir.
After reviewing the evidence, the documents, and listening to the statements, it has been your conclusion that the trial in this case would not be in your best interest.
Yes, sir.
And after reviewing the evidence, the statutes, and the law in this matter, you are before the court to admit your guilt and set out in the plea agreement, right?
Yes, sir.
And you are prepared to admit that you knowingly and intentionally engaged in illegal conduct as set out in the charges that I'm about to go through with you, correct? Mr. Noel, as it relates to count 1, corrupt business influence is a level 5 felony, is that your admission here today that a period of time between November 9th, 2018 and August 16th of 2023 in Clark County, you knowingly or intentionally through a pattern of racketeering activities acquired or maintained either directly or indirectly an interest in or control of property or an enterprise contrary to the form of the statutes set out in Indiana Code 3545 6.2 as against the peace and dignity of the state of Indiana.
Yes, sir.
And you admit those crimes.
Yes, sir.
As it relates to count 2, theft, a level 5 felony, do you admit that on the 3rd day of May of 2024, you knowingly or intentionally exerted unauthorized control over the property of the Utica Volunteer Firefighters Association with the intent to deprive Utica, the Fire Association, of any part or use of the value of the property, more particularly that you traded a Utica-owned Chevrolet Corvette, and that's in 2021, I apologize, Mr. Noel, that you traded a Utica-owned 2020 Chevrolet Corvette valued at $92,000 for a 2020 Mercedes-Benz, and that registered the Mercedes-Benz in your name, all of which is contrary to the form of statutes as provided by Indiana Code 354342, subsection A, 354342, subsection A, subsection 2, subsection capital A, as against the peace and dignity of the state of Indiana.
Yes, sir.
And you admit that you violated those statutes and committed that crime.
Yes, sir.
As it relates to count 3, theft, is that your admission here today that between January 2nd, 2019 and October 10th of 2019 in Clark County, Indiana, you knowingly or intentionally exerted unauthorized control over the property of the Volunteer Fire Association, hereafter I'll refer to as Utica, with the intent to deprive Utica of any part or use of the value of the property. More particularly, the property had a value of $50,000 or more, and on January 2nd, you traded a Utica-owned 2017 Chevrolet 3500 Silverado for a 2019 Challenger SRT Hellcat, and that you titled the Hellcat in your name. And on October 10th, 2019, you personally sold the Hellcat for $83,000, all of which is contrary to the Foreman statutes and set out in 3543.42 and 3543.42 subsections A2 and capital A against all the peace and dignity of the state of Indiana.
Yes, sir.
And you admit that you committed that crime.
Yes, sir.
As it relates to count 4, theft is a level 6 felony. You acknowledge and admit that between April 30th, 2021 and September 14th of 2022 in Clark County, Indiana, you knowingly or intentionally exerted unauthorized control over the property of Utica with the intent to deprive Utica of any part or use of the property, said property having the value of $750 or greater than $750, less than $50,000, that on or about the 30th day of April 2021, you traded a Utica-owned vehicle, a 2012 Porsche Panamera, and titled the Porsche in your name. And on September 12th, 2022, you sold the Porsche for $32,000 to a car dealership and deposited the funds into your personal bank account on the 14th day of September 2022, all of which is in derogation of Indiana Code 3543.4 and of the subparts.
Yes, sir.
And you admit that you committed that crime.
Yes, sir.
As it relates to count 5, theft is a level 6 felony. You admit that on or between the dates of December 2nd, 2020 and September 28th, 2022, that in Jeffersonville, Clark County, Indiana, you exerted unauthorized control over the Utica property with the intent to deprive the Utica property. The value of said property you took control of had a value of at least $750, less than $50,000. More particularly, on the second day of December of 2020, you traded a Utica-owned vehicle, a 1957 Chevrolet Bel Air, and the Chevy was in your name. And on September 27, 2022, you sold that Chevrolet for $39,500 to Kenny Eubanks and deposited said funds in your personal bank account on the 28th day of September 2022, all of which is contrary to the forms and statutes of the state of Indiana.
Yes, sir.
And you admit you committed that crime.
Yes, sir.
As it relates to count 6, theft is a level 6 felony. You acknowledge and admit that in between the 31st day of August of 2022 and the 14th day of September of 2022 in Clark County, Indiana, you knowingly or intentionally exerted unauthorized control over Utica property with the intent to deprive Utica of the use of that or the value of that property that had a value greater than $750 but less than $50,000. More particularly, on August 31st, 2022, you obtained control of a Kubota tractor. It was purchased in 2017 for $40,600 and sold it to James Boo Bishop for $31,000 on September 14th, 2022, and deposited the check of $31,000 in your personal bank account.
Yes, sir.
And that's all in derogation of Indiana codes and statutes set out 3543.4, correct?
Yes, sir.
And you admit that you committed that crime.
Yes, sir.
As it relates to count 7, obstruction of justice, you affirm under the penalties, you affirm and acknowledge here today that on or about the 16th day of August of 2023, you knowingly or intentionally altered, damaged, or removed records or documents or things with the intent to prevent it from being produced or used as evidence in an official proceeding, more or less, and in particular, you reset your iPhone upon the arrival of the Indiana State Police to obtain your property, and that is count 7, obstruction of justice.
Yes, sir.
And you acknowledge and admit that you committed those offenses.
Yes, sir.
And you admit your guilt here today.
Yes.
As it relates to count 8, you acknowledge that on and between the 9th day of November of 2018 and the 31st day of December 2022, in your but in order to be able to have the privilege, we're going to lay it. Yes, yes.
Okay, all right, I'm sorry.
No, you're fine. So Judge, the next several counts, we're going to use the factual basis to establish the basis for the plea to the predicate counts of official misconduct.
Yes, sir.
Thank you, Judge. So as it relates to count 8, you acknowledge and admit that between November 19th and 2018 and December 31st of 2022, you did, as a sheriff of Clark County and a public servant, knowingly or intentionally assign Michael Bowling, an employee of the Sheriff's Department, duties which were related to the operation of governmental agency that the defendant served with. You assigned Bowling to do duties on your personal property, rental properties, father-in-law's property, pole barn property, and Utica Fire Department property, contrary to the forms of the statutes that set out in Indiana.
Yes, sir.
As it relates to count number 9, you also acknowledge that between November 9th, 2018 and December 31st, 2022, and acting in your capacity as sheriff, you knowingly and intentionally assigned Donald Jones, who is an employee of the Sheriff's Department, to do duties related to the operation, and his duties were to work for the government, that you assigned him duties for your personal property, rental property, your father-in-law's property, the pole barn property, and Utica Fire Department property, and that's contrary to the statute of the state of Indiana.
Yes, sir.
You acknowledge in count 10 that in fact between the 18th day of November 2018, 31st day of December 2022, likewise you were the sheriff of Clark County. During that time you assigned Rodney Hubry, an employee of the Sheriff's Department, to do duties while he was working for the Sheriff's Department. Those duties were upon your personal property, rental properties, father-in-law's properties, pole barn, and property that was owned by the Utica Fire Department.
Yes, sir.
And then you acknowledge that in count 11, the same date and times between November 9th of 2018, December 31st of 2022, you in fact were the sheriff of Clark County. You did assign duties to Brent Fisher, an employee of the Sheriff's Department. Those duties while he was on government time clock, there were duties for requests and orders to do work on your personal property, rental property, father-in-law's property, pole barn, and property of the Utica Volunteer Fire Department.
Yes, sir.
And then as it relates to count 12, you understand that between the dates of November 9th, 2018 and December 31st, 2022, you were the sheriff of Clark County, which is a public servant. You understand that?
Yes, sir.
And in fact, as you testified previously, during that time frame, you engaged in conduct as it relates to Mike Bowling by assigning him those duties while he was an employee working on the county's clock. That is actions that constitute ghost employment, correct?
Yes, sir.
Then you acknowledge and admit that that is official misconduct as defined by the statutes in the state of Indiana.
Yes, sir.
And that is against the peace and dignity of the state of Indiana, and you admit that you are guilty of that as well.
Yes, sir.
As it relates to count 13, again, between the time frames of November 9th, 2018 and December 31st, 2022, you acknowledge and admit that Donald Jones was an employee while you were the sheriff. You assigned him duties while he was on the time clock for the Sheriff's Department that included the duties that you described for personal property and other properties that weren't sheriff's properties, right?
Yes, sir.
And you acknowledge that that is in fact also the violation of the Indiana Code related to the crime of official misconduct, and you admit that today.
Yes, sir.
And you acknowledge that that is a violation of law and you admit your guilt.
Yes, sir.
As it relates to count 14, once again between November 9th, 2018 and December 31st of 2022, you acknowledge you were the sheriff of Clark County.
Yes, sir.
And in fact, during that period of time, you assigned Rodney Hubry, who was an employee working on the county clock, to do duties and to undertake tasks at your personal property, your father-in-law's property, pole barn, as well as the Utica Volunteer Fire Department, and that also is a derogation of Indiana law, correct?
Yes, sir.
And you acknowledge and admit your guilt in count 14 to the offense of official misconduct, correct?
Yes, sir.
As it relates to count 15, you acknowledge and admit and agree between November 9th, 2018 and December 31st, 2022. In Clark County, you were the sheriff of Clark County, Indiana, correct?
Yes, sir.
And in fact, during that time, you Brent Fisher was an employee of Clark County.
Yes, sir.
And that while he was an employee and while he was working on the county's time clock, you assigned him and directed him to do duties on your personal property.
Yes, sir.
And property of the Utica Volunteer Fire Department and other entities that were not the government's entities, correct?
Yes, sir.
And you acknowledge and admit your guilt to count 15.
Yes, sir.
As it relates to count 16, theft is a level 5 felony. You acknowledge and admit that between February 5th, 2019 and December 31st, 2019, while in Clark County, Indiana, you did exert unauthorized control over the Utica Township Volunteer Firefighters Association property, which was the American Express card that you utilized, and then on that American Express card, you made charges in excess of $50,000, correct?
Yes, sir.
And that you did that knowingly and intentionally with the intent to deprive the Utica Township Volunteer Firefighters Association of the value of the money used to pay the bill for those items that you purchased.
Yes, sir.
You admit your guilt to that.
Yes, sir.
Count 17, that you acknowledge and admit that between the dates of January 1st, 2020 and December 31st of 2020, you in fact exerted unauthorized control over the Utica Township Volunteer Firefighters Association's property, more particularly and again the American Express card, and that you utilized that card in excess of $50,000 for charges that were unrelated to the Utica Volunteer Fire Department and Firefighters Association.
Yes, sir.
And then as a result of that, the funds used to pay those bills were funds that you exerted unauthorized control over without the consent of the Volunteer Fire Association.
Yes, sir.
You admit your guilt to those.
Yes, sir.
As it relates to count 18, theft is a level 5 felony. Once again, you acknowledge that between January 1st, 2021 and December 31st, 2021, you utilized the American Express card that was the property of the Utica Township Volunteer Firefighters Association with the intent to deprive them of the use and value of the property, their funds that they used to pay bills that you charged in excess of $50,000.
Yes, sir.
And that they did not have the benefit of the money that was used to pay those bills for items and things that were not items and things that benefited the fire department, correct?
Yes, sir.
And you admit your guilt to that.
Yes, sir.
As it relates to count 19, you also acknowledge between January 1st, 2022 and December 31st, 2022, you knowingly or intentionally exerted unauthorized control over the Fire Association's property, once again, the American Express credit card where you made charges without the consent or authority of the Utica Township Volunteer Fire Association in excess of $50,000.
Yes, sir.
Then Utica paid those bills with their money.
Yes, sir.
As a result of that, they lost the use and benefit of those funds. They didn't have the money to spend. And in fact, the things that you purchased were for your benefit and did not benefit the Utica Volunteer Fire Association.
Yes, sir.
And you acknowledge and admit that that is a crime in the state of Indiana, and you admit that you committed that crime.
Yes, sir.
As it relates to count 20, theft is a level 5 felony between January 1st of 2023 and September 28th of 2023. You acknowledge that you exerted unauthorized control over the property of the Utica Township Volunteer Fire Association with the intent to deprive the entity of the part of use or the value of that property, more particularly that you utilized the American Express card and charges were made in excess of $50,000.
Yes, sir.
And once again, that was done with the intent to deprive Utica of the value of the funds that they used to pay those bills.
Yes, sir.
And you did not have the authorization or the authority to spend it on the items that you purchased.
Yes, sir.
And that those items did not benefit the Utica Township Fire Department.
Yes, sir.
You acknowledge and admit that you were guilty of that criminal offense.
Yes, sir.
Count 21. You acknowledge and admit on the 6th day of March of 2019 that you made a false 2018 tax return and or you made a false statement in a 2018 tax return with the intent to defraud the state of Indiana, evade payment of taxes or any part thereof, and that is imposed by Indiana Code 6.3, and that's contrary to the form of statutes in such cases made and provided for in 63611A and against the peace and dignity of the state of Indiana.
Yes, sir.
You acknowledge that, in fact, what I've said in a long way is that you engaged in tax evasion and that you admit that you committed that crime.
Yes, sir.
Count 22 as it relates to the time frame between on or about April 6th of 2020. In fact, you made false 2019 tax return or made false statements in your 2019 tax return, correct?
Yes, sir.
And that was with the intent to defraud the state of Indiana or evade payment of taxes, and all in contrary to the form and statute of Indiana Code 6.3.6.11, correct?
Yes, sir.
Acknowledge that is a crime as well, and you admit those things.
Yes, sir.
Count 23, on or about May 16th of 2021, you acknowledge and admit that on that date you filed a 2020 tax return, and that was a false tax return.
Yes,
Correct. And that you made the false tax return with the intent to defraud the state of Indiana or evade payment of taxes or any part thereof as defined by Indiana Code 63611, and you acknowledge that that's against the peace and dignity of the state of Indiana, that you admit that you committed that crime.
Yes, sir.
As it relates to count 24, on or about the 18th day of April 2022, you acknowledge that you filed a tax return, correct?
Yes, sir.
That was your 2021 tax return,
Yes, sir.
and there were false statements in that tax return.
Yes, sir.
And those false statements were filed and created with an intent of defrauding the state of Indiana in order to evade payment of taxes, all of or any portion thereof in violation of Indiana Code 63611A.
Yes, sir.
Relates to count 25. You acknowledge that you filed your taxes on the 17th day of April 2023, correct?
Yes, sir.
That you filed a false tax return on that date, and that false tax return was a false statement for the purpose of defrauding the state of Indiana or to evade payment of all of or any part of your taxes that were due, correct?
Yes, sir.
And you admit that that's a crime in the state of Indiana, and you acknowledge you committed that crime.
Yes, sir.
As it relates to count 26, that it's set out between the dates of June 4th of 2019 and August 21st of 2023, and you knowingly or intentionally acquired or maintained an interest in, received, concealed, possessed, transferred, or transported the proceeds of criminal activity, and or you conducted, supervised, or facilitated transactions involving the proceeds of criminal activity, or invested, expended, received, or offered to invest, expend, or receive the proceeds of criminal activity, or funds that are proceeds or tax funds of criminal activity, and the person, and you knew the proceeds or funds were the result of criminal activity, and that exceeded the value of $50,000.
Yes, sir.
You acknowledge and admit that as a result of those facts, that pursuant to count 26, you are admitting that you engage in money laundering.
Yes, sir.
Count 27, you acknowledge that between the period of June 26, 2019 and December 31st of 2022, you knowingly or intentionally exerted unauthorized control over property of the Clark County Sheriff's Department with the intent to deprive the Sheriff's Department of any part of, value, or use thereof, and that these values are in excess of $50,000. Particularly on December 31st, 5 lawnmowers in the amount of $18,651. On July 20th, 22, an HVAC system in the amount of $6,539. On June 26, 2019, a Dodge Ram in the amount of $11,000. And on in December of 2022, 22 shipping containers in excess of $25,000. And you acknowledge that, in fact, those things did occur, correct?
Yes, sir.
And in fact, you understand and admit today that you engaged in the criminal conduct as set out in count 27 as theft, a level 5 felony.
Yes, sir.
As it relates to count 28, that between March 31st of 2020 and November 29th of 2021, in Clark County, you knowingly, intentionally exerted unauthorized control of Utica Volunteer Fire Association property with the intent of depriving the Utica Volunteer Fire Association of the value of that property that was unlawfully and intentionally utilized for your benefit was child support payments in the amount of $50,968.
Yes, sir.
And you acknowledge and understand that that is a crime in the state of Indiana, and you admit that you committed that crime, and that is theft as a level 5 felony.
Yes, sir.
Count 29, you acknowledge that between December 2nd, 2019 and January 21st of 2023 in Clark County, you knowingly or intentionally exerted unauthorized control over Utica Volunteer Fire Association property with the intent to deprive the association of the use or value of the property, and the value of that property exceeded $50,000. More particularly, in January 21st of 2023, a BMW that had a value in the amount of $21,000. May 1st of 2020, a 1957 Chevrolet that had a value of $40,000. August 13th, 2022, a 1966 Pontiac that had a value of $33,919. January 6th, 2020, a 1979 Pontiac that had a value of $20,000. December 2nd, 2019, a 1969 Plymouth Roadrunner with a value of $52,500. And on July 28, 2020, a 1959 Corvette with a value of $45,000. You acknowledge and admit that you exerted unauthorized control over that property and that the Utica Township Volunteer Fire Association were the owners of that property and you deprived them of the use and value of that property.
Yes, sir.
Mr. Wilder, I think there was one that maybe overlooked, the May 20th, 2020, 1970 Dodge.
I'm sorry. As Mr. Hurls pointed out, in addition, in count 29, the May 20th, 2020, 1970 Dodge in the amount of $45,000.
Yes, sir.
And you understand that that is a violation of the law of the state of Indiana, and you acknowledge and admit that you're guilty of that.
Yes, sir.
As it relates to count 30, you understand and acknowledge that between the dates of February 17th, 2022 and May 10th of 2023 in Clark County, Indiana, you knowingly or intentionally exerted unauthorized control over property of the Utica Township Volunteer Fire Association with the intent to deprive the entity of the value or the use of that property. More particularly, the property had value in excess of $50,000. On May 10th, 2023, an HVAC system that was installed at the Turnberry Mansion in the amount of $2,700. March 22nd, 2023, a chimney repair at the Turnberry property in the amount of $11,200. February 17th, 2022, an airplane purchased in the amount of $25,000. September 9th, 2022, an airplane repair in the amount of $16,616. And on July 13th, 2022, a Cub Cadet mower purchased in the amount of $11,000. You acknowledge and understand that those are properties that you exerted unauthorized control to the detriment of the Utica Volunteer Fire Department, and you did that with the purpose of prohibiting them from having the benefit of that, correct?
Yes, sir.
And you acknowledge that and understand that that is a crime in the state of Indiana, and you admit that.
Yes, sir.
On the 31st day, on count 31, you understand and admit that between November 9th of 2023 and March 29th of 2024, you knowingly or intentionally exerted unauthorized control over property of the Volunteer Firefighters Association with the intent to deprive the Firefighters Association of the value of the property, and the value of the property was in excess of $50,000. More particularly, there were American Express credit card purchases in the amount of $37,151 and Sam's Club credit card purchases in the amount of $15,667. You understand that that is a violation of the law of the state of Indiana?
Yes, sir.
And that you acknowledge and admit that you committed that offense in count 31, theft as a level 5 felony.
Yes, sir.
Judge, I have no further questions of Mr. Noel. Thank you.
Thank you, Mr. Wilder. Mr. Hurl, do you have any further questions of Mr. Noel?
Mr. Noel, you know you don't have to plead guilty to anything today, don't you?
I'm sorry?
You know you don't have to plead guilty to anything today?
Yes, sir. More of that.
It's your choice.
Yes, sir.
You're pleading guilty because you committed these crimes?
Yes, sir.
Nothing else, Judge.
Nothing related to those questions, Judge. Thank you.
Shameful. Mr. Wilder, do you have a motion?
Your Honor, at this time I'd ask Mr. Noel if he joins me in asking the court to give us an opportunity to withdraw our previously entered plea of not guilty to all of the counts that we have acknowledged we are guilty of, and enter a plea of guilty for each count as you've asked today.
Yes, Your Honor.
Judge, we'd so move.
Well, I'm not going to say yes, I'm not going to say no today. I'm going to take this matter under advisement. Mr. Hurdle, victims, as you are well aware, and Mr. Wilder's aware, have rights. And I'd like to hear from some of the victims, or a lot of the victims, at a date in the future in regards to whether they believe that this is an appropriate sentence or whether they don't believe it's an appropriate sentence. I think the offer is not inconsequential by any means. It appears that Mr. Noel spent approximately almost 10 years incarcerated with a period of probation. And everybody knows when you make a deal, I expect people to abide by it. When you violate probation, you serve the time, as I hope Mr. Noel has learned from my previous actions, that I mean what I say and I say what I mean. So, Mr. Hurdle, who may potential victims, and I mean not just management, not just the sheriff's department, I mean EMS workers that have lost their jobs, paramedics that are not out there saving people because the money was diverted for pleasures. I want to hear from people that don't have $800 belts. I want to hear from taxpayers that have been aggrieved by the actions of this individual. And Mr. Noel, if I don't accept it, we'll set it all aside, we'll start back over, and it'll be as if nothing happened. So who shall they contact?
Your Honor, they can contact my office directly, and I will put them in contact with the Victim Assistance Coordinator in Ripley County, who will be reporting them to me. I would represent to the court that I at least have spoken to some of the management and attorneys at Utica/New Chapel, and I've also spoken to Sheriff Maples, and we've spoken to the Department of Revenue. I'm assuming that they can get word out to their employees or former employees, and if there is a concern, I don't know that it's within the state's ability to contact every employee of those, but we will make the administration aware of what the court's order is today.
I understand. So, what number is that, Mr. Hurdle?
812-689-6331.
6331?
Yes, Your Honor.
Members of the press, I'm going to ask you to do a favor for me. Ask victims, and Mr. Bostock, you'll do the same thing?
Yes, sir. Just not now.
Not now, correct. Tell your viewers that if they believe that they have been harmed, that they are a victim, contact Mr. Hurdle's office at 812-689-6331. You may have to hire extra help, Mr. Hurdle, to take all the calls. I don't know. There may not be any calls. But my guess is 31 counts. There's going to be a few victims that may want to be heard, and I want them to have that opportunity. If it becomes so overwhelming, we may have to call some of them and select. But I want the taxpayers of Clark County to know that I'm willing to listen to them.
Your Honor, is it the court's pleasure that I instruct them to write a letter for the court to review, or that I said they are welcome to be a part of the next hearing to make their representation to the court?
I think they should be present. I'd prefer that I hear them live as opposed to receiving a letter. If they want to be heard, they ought to show up, in my opinion.
Thank you.
Mr. Wilder?
I've got nothing, Judge. Thank you.
Mr. Hurdle?
Nothing else, Your Honor.
Okay, we'll be off record. Hold on. Mr. Wilder, your client's entitled to be sentenced within 30 days.
Yes, Your Honor.
And I'm going to ask my probation department to do the pre-sentence investigative report. Do you wish to be present when she speaks with your client?
Judge, we believe that we want to be present when they interview our client. And then, Judge, at this time, Mr. Noel, you join me in asking the court to waive the 30-day sentencing time frame in order to allow the court to have an opportunity to make sure we have everything together at the time of sentencing.
Yes, sir.
Judge, we so move the 30 days.
Any objections?
No, Your Honor.
All right. Court will grant that request,
Thank you, Judge.
considering the number of victims and the number of charges and the amount of time that we've invested here today. I appreciate that, Mr. Wilder. So unless there's anything else from anybody else?
Your Honor, is the court's pleasure to set the date today, or we'll get notified from the court at a later date? Or when we?
Renee?
I think I'll call everyone and get up.
We're good. I got a miserable schedule, and the court will not, or my staff will not allow me to manage a calendar.
And if it pleases the court, Mr. Voiles wanted me to make sure that we get him involved since.
Tell Mr. Voiles I'm sorry he didn't get to come down and visit with us today.
I'm sure that he would prefer to be here rather than Fort Wayne.
All right, unless there's anything else, we'll be off record.
Thank you, Judge.
At 12:36.
Well, good afternoon, everybody, and thank you for being here. My name is Captain Ron Gallivan. I'm the Chief Public Information Officer for the Indiana State Police. I'm sure I've spoken to or otherwise communicated with many of you here in the room over the last 14 months. It's been a ride. The last 14 months has seen an incredible amount of investigatory. The arrest of former Clark County Sheriff Jamey Noel on November the 8th of 2023. This thing has picked up even more steam. And again, I don't need to tell you all about it because you all have been following this very, very closely in your reporting. This afternoon, Special Prosecutor Rick Hurdle has asked to have an opportunity to provide an update and bring us the latest in this really significant case. So, and I believe Mr. Hurdle will also provide an opportunity for some Q&A. So, at this point, I'd like to introduce Special Prosecutor from Ripley County, Richard J. Hurdle. Rick?
Thank you. Look like I'm taking up residence in Clark County. I want to provide, like the captain said, an update on kind of what's going on, but most of you have just sat through the hearing and the plea hearing with Judge Medlock and Jamey Noel. And as you heard, we will have a sentencing date. To be clear, Judge Medlock has taken the guilty plea under advisement. He's not entered judgment of conviction at this point in time and will not enter judgment of conviction until sentencing occurs. And he will accept the agreement or not accept the agreement at that point in time. As the captain said, there's been a lot of investigation for the last 14 months or so. And a special kudos to Detective Jeff Herron, who's the lead investigator in this matter, and Chris Hansen, the detective who has assisted him basically from day one, and it has been quite a ride. I will say that Casey and Misty Noel are set for trial October 28th. Judge Medlock issued an order last week outlining whether or not those will be joined for trial, and the sum of it is that if the parties can agree to a way to handle the jury, then they will be joined for trial. And if we cannot agree, they will be separate trials, and the oldest case would be tried first, which is Misty Noel. Next are the two defendants that were just charged last week, John Miller and Brittany Faree, who had their initial hearing and bond hearing this morning that many of you were also present at. The date in October is a pretrial, an opportunity to give the judge a status of where the cases are going and whether or not there will be a trial. The omnibus date, as the judge outlined, is a time in which both parties need to file certain motions by, and we do have a February trial date. So those are the 5 defendants that are facing criminal charges now. There's various ages, as you can see, with all 5 of them, and we're going to move forward kind of as time allows. And the next hearing date we'll wait for from Judge Medlock on the potential sentencing date. So I'll take questions. I do have to be in Ripley County, so I can't spend too much time here.
Rick, we hear a lot of times from victim impact statements with regards to sentencing. What do you make of just what the judge said regarding soliciting more victims to contact your office? What do you think of that, and how are you going to handle that?
Well, my office has been in contact with the management and the Sheriff's Department, as well as the Department of Revenue, as we've outlined in the plea agreement that you see, and that's how we came up with the restitution figures. I think it's going to be a lot, but I understand Judge Medlock's position that he wants everybody to have the opportunity how this crime has impacted them or their family, And if they are a victim, they should reach out according to him. And if it sounds like he's going to give each of them an opportunity to speak in open court, and if they choose that they don't want to speak, I'm guessing that he will read a letter, or if they want to type something up for him and pass that channel through my office, I think that that's what he's asking us to do, and that was a directive. We have complied with the statute. We've spoken to Sheriff Maples, and we've spoken to Utica and New Chapel and had conversations with them, as well as Department of Revenue. That's how we came up with those numbers.
But you may be getting dozens and dozens of phone calls now from multiple media outlets putting out your office number for contact. I mean, is that extraordinary from your perspective?
I think so. I mean, obviously, every prosecutor's office deals with a number of victims depending on what type of crime it is. But this could be somewhat overwhelming, and I hope that my staff can handle that. But I think we're going to comply with what the judge told us to do, and it sounds like it may take to do a sentencing hearing if all of these victims are going to be permitted to come in and testify. And I don't think it's my role to say, no, you can't testify, given the directive of the judge today.
After Ms. Marie and Mr. Miller's hearing, their attorneys came out and painted their clients as cooperative witnesses who certainly never knew Mr. Noel was stealing and certainly never took anything in exchange for a vote. Do you have to prove a quid pro quo, or was their mere status as council members and those interactions with Mr. Noel, is that enough evidence to prove the conspiracy?
Well, I'd refer you to the probable cause affidavit. One's like 15, 18 pages, and the other's like 21 pages. So we're basing the charges on that probable cause affidavit, and it's the state's responsibility, and in essence my responsibility, to prove each and every element of the crime beyond a reasonable doubt, and I think that's what we're bound by. No more, but certainly no less than what the statute outlines.
But does it have to be like a direct quid pro quo, or is it merely a conflict of interest? Are those two totally different things? That's kind of what I'm getting at.
Well, again, I'm going to refer back to the statute, and I'm going to be bound by what it says in the statute. And in fairness, there probably is not a ton of case law, such as in a drinking and driving or a murder case, where there's a ton of conflict of interest. But the law is on the books to protect people, and a matter of transparency. And we believe that, excuse me, sorry, that there was evidence of a crime, but again, it's going to fall back to whether or not we can prove it beyond a reasonable doubt, and the elements got to be met, and what's contained in the probable cause affidavit is what we're going to use.
What does the plea agreement, assuming it's accepted, do to Ms. Free and Mr. Miller's cases? Does it change them?
It doesn't change anything. And I think my only comment on that, coming down here, is job's not finished.
Two questions, sir. As far as the guilty plea today, what does that do to as far as the investigation into potential co-conspirators still remaining out there? Is that something that it's going to be a continuing investigation, or does it pretty much, paraphrasing, die with Noel?
I think that's a question maybe for the state police, but I think that I don't want to handcuff them if there's evidence of a crime, whether there's a co-conspirator or another defendant or someone else. I don't think it's in Detective Heron, and it's not in me to turn a blind eye to if we're presented evidence of an additional crime, to not at least look at it and weigh the options of potentially filing additional criminal charges on somebody.
Thank you. And the second question is, looking at Miller and Free, it appears you all have kind of chosen to use an umbrella charge. What is the theory behind not charging individual conflicts of interest and going with the one umbrella charge?
Well, I think that we just looked at the time period of which that they were members of the county council, and that's what we decided to move forward on, instead of trying to line out each and every time that something may or may not have happened.
Okay.
Why is 15 years appropriate? That seems to be on at least the lower end from when, of course, you're hearing the maximum possible penalties that were read at the initial hearings for Mr. Noel.
So it's the state's position that this is the upper spectrum of the actual sentencing range. you hear an F5 felony carries from 1 to 6 years, and then you're saying, Hurdle, what are you doing? He pled guilty to all these. Why can't you just stack, stack, and stack? Well, there's provisions within the state of Indiana that does not allow for things to be consecutive to one another, but allows for what's called concurrent, one with the other. And so our work in this, and provided by certain people that have helped me do this research, says that we are on the upper end of the spectrum of this 15-year sentence, and that's why we did what we did.
What's the top that he could or could have faced?
I think the top is subject to interpretation. It's not so black and white. If you ask some legal scholars, I think they may say 7 years. There may be other people that say 20 years. And I know I'm probably not answering your question and say just answer the question, but it's not such a black and white topic that I can just say here is the number, because there's single episodes of criminal conduct, there's multiple episodes of criminal conduct, there's concurrence, there's consecutive, and it's not quite so clear. But as I mentioned to Mark, that we believe this is the higher end of the spectrum of charges.
So it's 15 years with 3 years of probation after?
That's correct.
Okay. And in regards to the restitution for the victims, so UTVFA has just done a lot of layoffs, and they may be down to as few as 8 employees. So you're paying out $2.8 million to an organization that has just significantly downsized. Are you going to have any say in what they should do with that $2.8 million?
No, that's not my purview. That's going to be up to Utica, and if the judge accepts this agreement, if he sets certain provisions, and if he accepts it as is. So that would go to Utica for them to handle as they see fit. That's something I can't control.
Can you shed some light as to why the ghost employment charges were dismissed in the deal?
Well, the ghost employment merged with that official misconduct. If you heard Mr. Wilder, as he established a factual basis with the defendant, he talked about that he had these people, a number of them, 4 or 5, that worked on his properties, his father-in-law's properties, and a number of other properties, and that was in his capacity as sheriff. So they sort of merged together, and so that's why we felt the dismissal of those 4 counts was appropriate here.
Given that the judge would like to hear from taxpayers, people who don't own the $100 belts, and you've seen some of the language in his courtroom, are you concerned that he may not accept this plea deal?
Well, I think that's, again, a question probably better asked for him. I think that weighing everything and being involved from the very beginning, hearing the investigation, charging, and then working our way through the discovery process, we felt that this was appropriate. But at the end of the day, the judge has to say, I agree with you, Mr. Hurdle, Mr. Wilder, Mr. Voiles, Mr. Stewart, or he says no, and then basically it's like he said, that hearing never happened, and we start again and set a trial date. And if that happens, then we'll saddle up and go to trial if that's what we need to do.
I'll ask the elephant in the room. The timing of Mr. Noel deciding to go with a plea deal coincides with a lame duck governor that is a close associate. Is there concerns? I know my viewers have great concern that turn around in December 31st there's going to be a pardon of this. What is the likelihood, and what have you heard on your all's end?
I can't speak to that. I do not have the governor's direct line, and he's certainly not communicating with me, and I'm not communicating with him about the status of this case, and I have to control only what I can control, and that's the prosecution of Jamey Noel, and what happens after that, it's going to be out of my control, and so we're going to do our job, and then what happens, happens.
Rick, can you shed any light on the conversations that led up to Jamey Noel accepting this plea deal, the proverbial straw that broke the camel's back?
Well, that might be a question you have to ask Jamey Noel. What was it in his mind to do it? I can't connect with Jamey Noel. Everything is through his attorneys.
Your conversations with them?
My conversation with them, ultimately, that I think I sent it out last Friday, was that he's admitting guilt because he committed the crimes. You heard the question, the very 1 or 2 questions that I asked him. You don't have to plead guilty here today. Why are you pleading guilty? It's because he committed the crimes. So that I can only speculate that that's what he said.
Would it be fair to say you were a little surprised to get that notification that he was wanting to plead guilty?
I think you do this long enough, it's hard to get surprised, but I think that an agreement to 15 years of a sentence, at least proposing it to the court and to the judge, we've come a long way since that initial hearing back in November of 23.
Do you think you were a faithful steward of the people of Southern Indiana in your regards and special prosecutor in this case? And do you think they should be proud of the deal that you've gotten both sides to agree to?
You'll have to take a poll down here. I don't know. I mean, I'm probably not for everybody, but I feel like there's been a lot of time and a lot of effort and a lot of heartache trying to take into consideration the folks in Clark County, the victims in Clark County. This is new terrain for me. I'm 2 hours away from here, and I'm at times a little bit of a fish out of water. But I feel like I may be biased, but the work that the state police have done and the attorneys who've assisted me, they should be given a ticker tape parade.
Do you think this case will serve as a deterrent to future public officials' misbehavior?
Yeah, I think sometimes you can change criminal mindset and sometimes you can't. And whether or not this changes somebody, I hope so. I think that him going to prison for 12 years, if the judge accepts this agreement, should be a pretty big deterrent for a guy who lived the lifestyle that he lived leading up to this. I mean, you all know the charges on the American Expresses and the judge talking about $800 belts and Tom James suits and $180,000 there. It's about to be a wake-up call if the judge accepts this agreement.
2 questions. Time for 2 questions.
So with Jamey Noel and the questionable spending from the sheriff's commissary, I know council members in Ripley County have brought it to attention, at least according to news articles up there. Do you see the potential for some revamping of the requirements and basically the strings attached to the sheriff's commissary fund? I mean, he was paying $10,000 a year to Sheriff's Youth Ranch, just like your all sheriff up in Ripley County was.
I think that's something for the council, the commissioners, or the legislative body to deal with. That's, again, out of my purview. I mean, that it's something that I don't control or can't control. Yes, sir.
Do you anticipate, just based on the investigation so far, additional indictments, additional defendants?
I think there's a possibility of that, yes. We're not prepared to move forward today or tomorrow. I think we're at least evaluating Jamey Noel's guilty plea and the initial hearing with Miller and Faree, and I think one step at a time.
Will he be asked to cooperate with you guys?
His plea agreement does not call for any cooperation, so I don't think that that's on the table.
All right. Thank you, ladies and gentlemen, for being here today. I appreciate your time and your patience. And that concludes this media availability. Have a great day. Thank you.
Make sure you come back tomorrow so you don't miss the wild mistress hearing. Learn how she got a little sneaky and tried to avoid getting arrested. Maybe, sort of, might have been, while her kid was just chilling at school with no way home. It's a hot mess. Thank you for the support as always, and I will see you next time.